Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a globally known hate factory located in central Minnesota. And today, you know, we've got what is this? I can promote merchandise in the chat? What? YouTube added a thing. They added a thing that I didn't know was a thing, and now I don't know what to do. That's weird. Here, what? Look at all this merchandise. Here, I'm gonna try this out. Let's pin the... Yeah, I want to do that. I want to pin the smug mug. Pin it. Pin it, baby. What does that even do? Is it pinned? There's a smug mug pinned up top. That's cool. That's cool. I'm just kidding. I'm going to unpin it now. Sorry. I didn't know that was a thing. If I come out with a new thing, I can pin it. That's cool. That's a neat thing that exists that I didn't know existed until just now. Literally just now. Okay, now show me the super chat thing, though, so I can do that. Why is this screwed up? I hate everything. Good job, merchandise pinning. You've ruined the chat for me. Oh, there it is. Oh, thank God. That was going to make my job so much more difficult. So anyway, sorry for the distraction. What's up? What's up, guys? I'm going to... What is happening here? I'm, like, glitching back and forth. Oh, we've got stuff happening. Let me get this. Pause my backup. How dare you? How dare you try to back up? This is a live show. It's live. It's live. Okay. So what's going on today, guys? We've got some documents to go through. We have got a bunch of filings in the case that did not get gone through. That's proper That's proper diction or whatever. What do we got? Do I have these already? No. I'm going to have to go manually get them. All right. But anyway, so we've got, we've got the Beard Harris, Martinez Sue or whatever, responses to the motions to go through. We've got Lemoyne's supplemental brief that he filed yesterday prior to the ruling coming out. We've got Lemoyne whining today. And before I make fun of him, which I'm going to, let me just acknowledge that what Lemoyne did today is exactly what Lemoyne is supposed to do today. Okay? Let's put that out there. He should absolutely, if he intends to, appeal this, he should, I guess, try and get, the judge on the record as to the court's findings of facts and conclusions of law, so then he can go ahead and have more appeal points rather than just saying it was wrong. Well, I shouldn't say he definitely should do this. Probably. Maybe. It's a stylistic choice, if you will. He could have just appealed off of what was in the hearing. Wonder why. He might not want to do that. But he wants the court to put its reasoning down so then he can start picking apart and challenging the reasoning. But I'm going to make fun of him for it anyway, because he and the little spednots who are totally no longer watching, they don't even care anymore. Right? You caveman looking moron. I'm not going to even pay attention anymore because Nick's wrong and stuff. Oh my God. What an embarrassing pile of thing that is. But all the little sped knots out there were critical of Vic even deigning to appeal a bad order. What he considers a bad order. When I say bad order, I mean from the perspective of the party that is aggrieved, right? He should just cut his losses and run. You know what he should do? Not only should he not do the lawsuit, he should pay Monica and Ron $2 million. That'd be fair. That's what he really should do. Then he should hire a PR firm and work on how to appropriately end his own life peacefully. The advice that these people have is stunning. Stunning advice. So, of course, since Lemoyne got a haircut on fees, and if they're all, of course, mischaracterizing what happened yesterday as somehow me proclaiming victory, which is not true. Expressly untrue. And simultaneously calling it a win or a loss for Vic. It's not a loss for Vic. Vic already lost. It's not a win for Vic because Vic doesn't win anything at this point. That's for appeals. But it's a big, big loss, a financial loss for either Lemoyne or his clients, and Volney or his client. Somebody's losing money there, and that somebody is not Vic as much as it could have been. And that is the sweet nectar of hilarity, because Lemoyne flushed it down the toilet. I said when he filed his idiotic ranting on fees that he was shooting too high, he was asking too much. He was asking the court to do something that the court wasn't going to do because he overbilled, obviously, and then demanded a bunch of depositions and wasted a bunch of time rather than just file reasonable fees. File reasonable fees. He probably could have gotten $180,000 to $200,000 in fees if he'd shut his stupid twitchy mouth. If he just filed for the fees. But he didn't do that. He bothered Chupp with hearing after hearing and motion and paperwork after paperwork, demanding all of this stuff, going for oral argument, trying to depose Slatosh, trying to subpoena Ty. And it all looked really, really desperate. And what he could have just done was filed for the fees. And not have to answer that question. Wait, this guy did it for $48,000. Why'd you charge $270? You misread the room again, Lemoyne. Didn't want to hear your stupid voice. I don't think Jay Sean got it. At the TCPA hearing, it was apparent to anybody with any sense of humanity in them that the moment Lemoyne opened his mouth, Chupp wanted to never ever hear another gaspy, wet breath escape those disgusting lips. He never ever again wanted to hear this man speak. Never. I'm not interested in your PowerPoint. Get to the argument. That's your warning. That's it. That's all you get. That's when you've got to know. Then what you should do immediately is get to the argument and then shut up. But you didn't do that. You almost gave Chupp a reason to allow it to proceed at TCPA. That's how Lemoyne should be Vic's attorney and argue against Vic, because it probably helped. That's the sad thing here, is that Jay Sean Lemoyne of Wick Phillips was so incompetent and so unlikable that he put his opponent in a better position by merely existing in the room and engaging in vocal communication. That's all it takes. If he had just drafted his fee review, or his fee request. His drafting was fine. If he had just drafted it and not raised a stink about it and not given a bunch of people the opportunity to look into it, not said, we're going to submit the billing. We don't want to publicly submit the billings. Oh, good. You just put everybody's eyes right on the billings. Perfect. Great job, you moron. We want to depose Slatosh. Why? Well, we want to go over these things. You already won on those things. Why? Oh, God, you think you didn't win on those things appropriately. You know, I've heard a rumor out there. I've heard a rumor that there was someone at Wick Phillips who knows they lost on, or they should have lost on TI. And that Wick Phillips might have been very, very confused and shocked by that decision because they expected to lose on TI. So you got two questions. One, Lemoyne, why are you drawing attention to that TI that you know you should have lost? And when I say someone from Wick Phillips, I mean an employee, a staff of Wick Phillips, staff member. They know. But the question is, why are you drawing attention to the TI? And the other question is, if you're so confident in that victory and you're not incompetent as an attorney, why would you risk drawing attention to the TI? Oh, if you thought that the evidence that they had was sufficient to pass TCPA on the TI, but you also thought that that evidence in the record was not correct, and that if you could sneak in the correct evidence into the record, you might be able to then introduce that on appeals to make an argument against the evidence that's on the record right now. You try and nullify it or correct it or show some sort of perjury. Get that pesky evidence out of there, right? That makes sense. That makes sense. Okay. Bad move. It was a bad move. The same bad move is bringing Vic on the stand. Vic, who is likable. You are not. Maybe you don't process this because you think people see you objectively because they tolerate being in a room with you who is disgusting. All right? So I get it. I get it. People are polite enough to you, probably because they've never actually interacted with you, that they will be in a room with you. And so what you assume is that when people are in a room with you and they're stomaching that for a while, that they then treat everybody the same way. Because they treated you with polite deference, they treat everybody just with polite deference. Well, that's not true, though. See, when someone with actual charisma walks into a room, other people like to engage with them. They want to listen. They want to hear them. That's charisma. That's a charisma score of, above 16 or whatever. They're sitting there wanting to talk and interact with the person, not just passively deferentially letting them exist in the same place. So you thought that when you brought someone in whose literal job it is to entertain people and who's had a career of it for 20 years, that the entertainer would be less tolerable or at least on equal footing with you. And that's an unfortunate thing. I don't know if that's the brain aids or if you've got some sort of autism that doesn't let you understand how people work, or if you've just been conditioned by that passive acceptance in your own experience to not realize that. And I don't even think this is related to the West Nile. I think you were probably absolutely insufferable prior to it. So make no mistake, this isn't about your disease, pal. This is about just you. I don't think you've figured out how that works. That there are people enjoy being around and people tolerate being around. And that when you mix those two, the enjoyment one is that's gonna have an advantage, a leg up, if you will. Anyway, but all of that was bad for you. It's bad for your fee decision. Again, I know I'm just a fourth year and I don't know anything. I got it. Okay. Yeah. Here's the thing. If you would have asked me if you should have brought Vic on the stand, I would have told you no. Under no circumstances should you do that. It'll be a nightmare for you. And when the transcript comes out, that'll not help you at all either. And if you would have asked me if you should have tried to go after Slaytosh, I would have told you no. One, Slaytosh told the truth in the affidavit, and that's one big hill that you have to overcome. Because your clients are liars. I don't know. Have we told you that your clients are liars? They lie constantly. And if you don't know that, then they're lying to you, and that's a shame. If you do know that, it might be more of a shame. But your clients are liars. Slaytosh is telling the truth. So going after Slaytosh is going to end up badly, because all he has to do is get up there and say what happened. And you look bad, and your clients look bad. That's just the way it goes. So I would have told you, no, don't go after Slaytosh. Just file your stuff. The judge just gave you a full victory when you know. And Lemoyne, I know you're not this stupid. You know you should have lost on at least one, if not two, counts for both of your clients. You should have lost. And you could have lost on all four. You could have lost on all four. There's plenty of evidence for all of it. But you know you definitely should have lost on TI for both of them. You should have. So you already knew this. And Chup gave you the clean victory anyway. Why in God's name would you stir up the hornet's nest on that? Just realize he was going to give you whatever fees you wanted. But you didn't read the room. You made him do a bunch of work. Now you're asking him to do more. Okay. I hope that goes well for you. Really do. Oh, you flippin' idiot. It's weird. It's weird. I don't know. By the way, if you guys are ever attorneys, and if you've ever been an attorney for 20 years, and you ever passively dismiss any other attorney for whatever reason, you're a moron. You're flat out a moron. Never passively dismiss an attorney. Because you don't know anything about what they're capable of. So, I mean, I guess that's just another mark against Lemoyne. But he's good at making the snap judgments, right? Everybody who doesn't agree with him's an incel. All of that. He doesn't hold all of the hallmarks of a standard internet moron. He doesn't have any of that. He's just got, you're just an incel in your mom's basement. You're trying to peek at your mom in her underwear. What is wrong with you? Oh, God. I suppose that should just translate into his career as an attorney. Anyway, I should probably stop yakking on about this, and we should get to some documents. We're 5 minutes from like the normal, I guess, top level, the level of viewership that normally will come into a stream. We're sciencing this stream, y'all. We're sciencing everything. So let me bring up the documents here. Gotta grab them. We gotta go ahead and grab these bad boys. Okay. Texas is probably like, why is this lawyer in Minnesota buying all this crap from us? What a weirdo. While I'm doing this, how's it going? How's it going there, guys? How are y'all? Hope everybody's having a good day. Man, the whites on the screen. We gotta stop the whites. We gotta stop the whites. Okay. Post-hearing brief for sanction fees. 19 pages. Oh my God. What a moron. Okay, this is an interesting document. I didn't really see this one. This one. Oh boy, we got all sorts of stuff here. Okay. Let's let me go to the, gotta check out on my shopping cart here. Okay. Buy these documents. Okay, good. Woo! Woo-hoo-hoo! This is probably the website where my debit card was compromised or whatever. I don't trust you, Texas. I think we should go in maybe like reverse order. What is this? No, down. Oh my god. Hold on. Gotta get this in the right folders. See, whenever I'm navigating through like Windows Explorer menus, that's when I feel the oldest. Okay. There we go. Let's get this pulled up. Aha! Heh. Here we go. That's the, this is today. So we'll go kind of in reverse order, because that's what I want to do, I think. So I'll get this next one pulled up too. I want to focus at first, at least. I mean, the others all came in at the same time, but we're going to go through today's filing and yesterday's filing first. They shouldn't take too terribly long, and then we'll get back into the stuff from Vic's team after that. First, of course, we're going to hit the $20 super chats and then get onto the documents here. So, Barocco Gaia says, "Hey Nick, celebrated having lost 87 pounds in less than 6 months intentionally. Bravo. I like listening to your streams while I'm out walking. Thanks for laughs. 80 more pounds and I'll be at ideal weight. You can do it. You can do it, man or woman. I'm gonna guess man, because Barocco. But I don't know. I don't know if Barocco Gaia or is like Baracco Gaia. Is that like a joke about Obama, or if it's a real name? I don't know. Because it's YouTube. I never understand. But you can do it, buddy. Keep up the good work. West Nile Chan says, ready for the next Legend of Lemoine Skyward Awards. A rhythm game where you press A to inhale and B to exhale. Mess up and you'll fall unconscious at the hearing, costing your client thousands. A bit buggy. Use an antivirus. No. Oh, guys, I got to tell you my idea. My idea for something in just a second. Ace Brain 2003 says, "Hey Nick, what are your thoughts on the Tesla Cybertruck? Man, that thing looks weird, but it's probably nice inside." Okay, I'll tell you my thoughts on why it looks like a 1980s kid's dream truck on Mars is because Teslas have an almost distinct look. They're almost distinct. If you know what you're looking for, you see a Tesla on the road, you know it's a Tesla, even without the little T. You don't know what you're looking for, you're like, oh, okay, I don't know if I've seen one of those. And then you look at it and you're like, oh, it's a Tesla. I've heard about those. Those are cool. The Cybertruck is obviously a Tesla. There's nothing else that looks like it. Nothing is going to, because it looks horrible. It looks frankly just terrible. And that was intentional, because it doesn't matter that it looks terrible. Everyone on Earth will know that you're driving a Tesla truck, and that's what someone wants. They don't care if their truck looks good. They care if you realize they're driving the Tesla truck. It's the whole purpose of it. It's kind of the purpose of driving a Tesla. And I like Teslas. I'm not bad-mouthing them at all. But you want people to know you're driving a Tesla. It's a statement car. for any number of reasons, either because of the environment, the technological innovation, the price, the cool factor. Doesn't matter what it is. People want other people to see them in a Tesla. That's part of the statement that the car is making. It's like a Corvette or a Lambo or whatever. Like, it's half about the car and half about people seeing you in the car, right? Like, that's what you're going for. So if it looked like a Dodge Ram, no one would care that you're driving that Dodge Ram that's electric. So there's my thoughts on it. And just because something looks terrible doesn't mean that that's bad. And it's not a criticism in that way. It looks like, you know, something from an old sci-fi movie. It's not a design that's contemporary. And it's not, which, again, these are not bad criticisms. This is just my impressions of how, what they're trying to do to draw a distinction. I think they've done a great job of it. As for the truck itself, I don't know anything about the performance. Teslas are really cool on the inside generally, so I assume it is too. Mithra Nemra says, if Lemon Boy keeps his behavior up, you'd use him as a case study in a professional responsibility and ethics class. If his clients have any brains, we'll be doing a case study on a malpractice suit. Yenri Stark. See, this is the problem, though. I have made a gross miscalculation. I've made a gross miscalculation, and that is, I spent so much time mocking horse teeth Monica and wife beater Toye. Like, I can't. They so thoroughly distrust me now. It's the same with Maddox. It was a rookie mistake then, and I made the rookie mistake again as a non-rookie. I made fun of them too hard. I flew too close to the sun, which melted my wax wings, and I plummeted to the earth before I could convince them to sue their moronic, malpracticing attorneys who are just busy going deep over and over, despite their cries to stop. They're just really, really pushing it in there as hard as they can. There's nothing I can do about it anymore because they don't trust me, because I called Monica fat one too many times. I should have thought it through, but I didn't. I should have, but I didn't. But they don't realize that if Lemoyne actually bills them this, that they overpaid by quintuple. The Chup is trying to tell you, you overpaid by quintuple for the work that was done. And if they just realize that, if he just bones them, if especially if it comes back on appeal or whatever, and he's like gone because the TCPA's over or whatever it is, however that works out, man, oh boy. But they won't listen. So now Lemoyne's gonna be like, no, that's just the Shockjock talking. You can't listen to him. My fees are justified. Write me a check, bitch. That's how it's gonna go. And I'll be sitting here like, no, don't pay him. Hire some other attorney to sue him. Hire Ty to sue him. It'd be funny. You'd at least hit maximum memeville. You'd hit maximum memeville and you could turn Lemoyne into the villain of the story and it'd be the funniest thing on earth. I know I've heard your jokes. You're not funny though. So it's anathema to you. But it would be the funniest possible thing you could do. It'd also be fantastic for you to re-energize that fan base that you've been mocking, deriding, and hating for so long. They might find it funny enough to forgive you. Maybe. I make no promises. But that's the path. There you go. Don't hire a PR firm. Don't hire a PR firm. Don't do anything. When you can't get to conventions anymore because you're just a toxic property, and you're big enough to be called property, but you're a toxic property, don't hire a PR firm. Just remember what Little Rackets told you. Just sue Lemoyne and hire Ty. Memes are dreams in 2020. Just do it. Everybody will be on your side. I'll be on your side. 100%. I'll do a GoFundMe for it. I think it'd be the greatest thing in history. Nothing could be funnier than that. I know you won't listen. Just like Maddox didn't listen to me. I told Maddox to sue Landau. Told Maddox, talk to a malpractice attorney because Landau is boning you hard. He's screwing it up. He's screwing up the case. He's setting you up for that sanction. Now, thank God, Ramos decided to retire because that sanction was coming until you got that weird new judge. Anyway. Oh boy. Okay. Back to it. Yenry Star says, first super chat. Oh, what is in my ribs? It's Brutus's knife. No, I'm just kidding. Yenry Star says, first super chat. I'm a good 6 videos back or so, but I finally caught you live. The Vic GoFundMe makes my bank think fraud is happening. Must be Moronica fans, but I'm going to try again. Just wanted to say thank you for being awesome. And since it was brought up, let's go ahead and bring it up. We are at $263,650. Thank you so much to let's see who we got. Manny Alvarez, Anonymous, the Texan 83, Anonymous, Ryan Stewart, Joseph Corcoran, Corcoran, Can't Touch This, Miles Roast, and Joseph Cole. I think that's back where we left off before. So thank you all for the donations. Again, every dollar. It's like what is it? You know, for just 10 cents a day. For just 10 cents a day, you can make a horse cry. Or whatever. You can feed a starving mosquito at just 10 cents a day. Oh, there we go. I couldn't find my window again. Okay. Anyway. That guy over there. Oh, where'd we go? That guy over there says, for the first time, I just saw a Funimation commercial promoting their Funimation Now streaming services on TV. After last night's show, that commercial clearly screams, give me your money. War God 739 says, what a big win being able to re-urge the Slatosh deposition must have been, seeing as how it was never brought up at the hearing. Oh, remember Law Twitter running laps? He gets to bring it up. Oh, big victory. Nick was wrong about that. Looks like the judge sided with Lemoyne on that one. Oh. All the best reads. Law Twitter is all the best reads. Oh my God. Whew. RZEQDW says, week gets more and more miserable as I realize how lonely I am going to be during Thanksgiving. Come to Minnesota early. Get here on Thursday. You can eat at my house. I don't know what my point is. I just need to vent. Things has sucked for months. Nothing will change in the foreseeable future. Man, if I had family in your town, I would send you there personally, but I can't. I wish I could be with you this Thanksgiving, buddy. But soon. Trouble Lord says Funimation estimated revenue is $35 million. How much did 6 months, give or take some time, of court battles cost? How much of $35 million is net profit or gross profit? They still have appeal costs and lawyers to pay. I don't know. It depends on if they're paying Monica's lawyers. But really, the question is how much did it impact their revenue to have the fans pissed off at them? Like, if you think about this, so Funimation streaming service, what? $10 a month? 15? 8? What is Funimation streaming service? All right. New releases every day. $8 a month. $8 a month. Now let's say I don't know how many I don't know how many people pay, how many people do the subscription service, but let's say 500 people decided to no longer do it after they fired Vic. 500 times 8. $4,000 a month times, it's been 11 months or 10 months. 40 grand. That was easy math. Why did I do a calculator? Let's say that number is 5,000. Then it becomes 400,000, right? Like orders of magnitude. I don't know how many subscriptions they lost. I don't know how many subscriptions they didn't add. But every one of those is lost revenue, and it's fixed revenue. Or they have flexible revenue and fixed costs. That's what they have. Because the cost of doing shows are minimal, distribution, all that can be planned out. What they can't ever plan on is exactly how many people will subscribe. So unsubscriptions hurt them directly and in a real tangible way in this type of business. So who knows? Who knows how much it costs them in the long run? I did not pregame for tonight's stream. I wish I had. Anyway, E1337 Neo says, "Hey Nick, pair of sawbucks for the whiskey fund. Having you on in the background as I burn midnight oil for work is making it more bearable. By the way, Jay Sean Lemoyne versus Kevin Landau. Wouldn't that be a death battle for the ages?" Well, one death battle in the literal sense that one might die before the battle was done. And that's just unfortunately how it could go. And then finally, Nigerian Paralegal says, if J Dolph's extra work was because they were trying to get info to build some sort of case against other parties, how does that play into the malpractice theory? Not TCPA related, but might have been what his clients wanted. Might have been what his clients wanted. And he probably should have counseled them against it. Especially if that someone is a Minnesota lawyer with very little cost of entry to the legal system and a whole lot of ability to maybe profit from such a miscalculation. Except, as shown over and over, these people can't read the room. So they don't realize that suing a YouTube personality might be a terrible choice. Might be a terrible choice. Just maybe. I don't know. Maybe they should ask Maddox how it was to sue someone with a platform. I don't know that Maddox should have ever made that decision. Gay and Still Large says, "Hey Nick, I got home tonight from my grandfather's funeral." Oh man, I'm sorry to hear that, buddy. He was a veteran, a Christian, and a second father to me. Been hard, but watching replays of this stream have been a nice way to remember how to laugh between the tears. This 20 is my thanks. Hey, you're welcome. You're welcome, brother. And to your grandfather. Grandfathers are the men who had the opportunity to teach us and never the required burden of discipline. So you always knew that when you got disciplined by a grandfather, that you probably deserved it. You probably deserved it because they didn't have to do it. They felt it necessary. I miss both of mine very much. Okay. Next, we are going to look at these. Oh, I was going to tell you my idea. And then we're going to do this. So, as you guys know, I have a Twitch channel, or you may know, you may not know. I have a Twitch channel, which I do post-stream cool-down video game sessions. And I've been playing Pathfinder Kingmaker, which is great. I can't believe this took me so long. Rangers in both Pathfinder and in Neverwinter Nights have hated enemies, and they get to hate a race. So I thought that it would be really funny to do a playthrough with my main character as a ranger named Richard Spencer, who obviously all of the races that he hates, first and foremost, your first hated race is going to be like half elves or half orcs or whatever. And then the other half elf or half orc, and then just orcs. Like, and so it'll be Ranger Spencer running around race hating. That sounds like, why didn't I think of this? And then just like always, no matter what alignment or role play implications there are, just flat out murdering every orc, half elf, half orc. Can't have that miscegenation going on in my fantasy game. So Ranger Spencer, that's gonna start sometime soon. I was driving today and I started just screaming in the car at myself for not thinking of this just like a week ago, because I just started the Pathfinder campaign. So be careful with Twitch mods. We'll see. It's part of the game. The Ranger hates those races. Race hating is in the game. Why does D&D still allow race hating? Oh my god. Oh goodness. Okay. Anyway, let's get to these. I'll announce when Ranger Spencer is gonna be trying to peacefully relocate all the half elves and half orcs out of whatever game setting I'm in. I'll announce that. But those are the stupid antics that sometimes happen on Twitch. Anyway, Monica Rial and Ronald Toye's request for findings of fact and conclusions of law. So this was filed today after the ruling yesterday in Lemoyne voice. Defendants Monica Rial and Ronald Toye in the above styled and numbered cause requests that this court file findings of fact and conclusions of law pursuant to Texas Rules of Civil Procedure 296 and 297 related to the November 25th, 2019 final judgment solely as it relates to reasonable and necessary attorneys' fees awarded to them in the amount $100,000 through November 21st, 2019. Respectfully submitted, J. Sean Lemoyne. All right. Now, of course, I have to make fun of this. Lemoyne is going to appeal how low the fees are. He has to. He has to. He has effectively cost Wick Phillips $180,000. Effectively. Cost them that money. Because they've billed $280,000. They were awarded $100,000. So far, somewhere around $100,000 has allegedly been paid. So it doesn't matter who paid that. That $100K comes in for attorney's fees. Clients are going to be like, where is that money? We should be reimbursed the $100,000 that we did pay. Say, no, you got another $170,000. Well, I don't know if that bill's right. So right now, he has cost his firm $170,000. He has to file this. Has to. Because otherwise, probably more than his annual salary has just been flushed down the toilet. And that's not a good thing to have on your record. He has to try and get that money. So just know that he has to do it. That being said, oh, imagine the possibilities. Let's say Chup goes through the filing and determines, well, maybe it should be lower. Maybe his findings of fact and conclusions of law support a lower award than $100,000. Maybe he just goes through and just pulls out all the redactions. And all the redacted stuff, I don't even know what that would come to. That'd be a great question. I don't want to task anyone to do this, but if anybody out there during the stream feels like going through the billing and tallying up everything that's not redacted, just start there and see what the amount is of unredacted charges. You just, calculator and calculate out everything that's not redacted. I'd be really curious about what that would come out to. That might just get Chup off the hook. Of course, Chup will come to the findings of fact that Sam Johnson was able to do this and do a better job for $48,000. That's a finding of fact. For $48,000, a non-specialized attorney was able to achieve the same result. Therefore, he can justify double that award for a specialist attorney. See, Chup can go at this a couple different ways. I said yesterday that Chup awarded roughly 50 grand to each defendant, which is kind of true. That might not be how Chup came to the answer. Jay Sean is a specialist in TCPA. Sam Johnson was not, and neither is John Volney. So what Chup could do is say, no. Monica Rial and Ron Toye were joint defendants with one counsel, so it's duplicated work. So what I actually did was I determined that the specialist attorney, his bill was justified being twice as much as the non-specialist attorney because his hourly rate could be twice as much because of specialization. He could do that. That could be his justification as well. We don't know. I don't know what's in Chup's mind, but his finding of fact could literally be Sam Johnson's hourly rate of $250 an hour, or I think $350 an hour with the acceleration clause that he put in, compared to the Wick Phillips average hourly rate of $575 when you combine Jay Sean and the senior partners rates that worked on it. That it worked out to $575, and that specialization rate was justified based on Sam Johnson's rate, and therefore that merited the $100,000 ruling as opposed to a $50,000 ruling. He could absolutely do that. He'd be justified in doing it. The trial court has broad discretion in how they determine these fees. There's no specific way. It's just reasonable attorney's fees. Chup could literally just say, we found that they charged everybody this, but this court's opinion, the reasonable charge for this sort of work is $100,000 or is $50,000 per defendant, or $100,000 for a specialist and $50,000 for a non-specialist. They could do whatever. The TCPA is designed to reduce fees, not inflate fees. That's a conclusion of law, and therefore I cap it off at this amount for this reason. We'll see. We'll see. And then sure, Lemoyne can take that to the appeals court and try and argue it's something different. Now, Chup is going to now, if he didn't before, and I have a feeling Chup didn't. Sorry, Chup. If he didn't do the work before to justify this number, if he just said, okay, I'm just going to give everybody 50 and that one guy less because he asked for less. Now he's going to go back and retroactively justify the amounts he put in his final order. Now Chup is going to have to work harder to justify the amounts. This is the double-edged sword of asking for this finding of fact and conclusion of law, right? Is now Chup has to go back and add details that Lemoyne might not be able to effectively argue against. This was probably a tactical choice. Remember when the TCPA ruling came out, right? And I said, there's no findings of fact or conclusion of law in this ruling. This is a bad looking ruling. It should be more fleshed out than this. We don't know what basis he used to determine these things. Well, Vic could have requested a finding of fact and conclusion of law and then taken that to the appeals court. But what would that have done? It would have given Chup the opportunity of going back and adding a good legal argument to why he made the decisions he did. Instead, Vic's appeal is going to rest on what's on the record, not on what's on the record plus Judge Chup's very specific legal reasoning. And maybe he'll be able to come up with some very good legal reasoning for this. And that's the risk you run. I don't know that I would have taken this toll. I definitely would have appealed the ruling. I would have appealed those fees. Unless my clients are having their stuff paid for by someone else, I would definitely appeal the fees. Or if I thought maybe I wasn't going to get paid, I would definitely appeal those fees. Now, if he'd gotten his money in advance or was only 1 month behind, different story. But no. he's basically got to appeal the fees. So there's that. Nothing here. Not important. There's no way to contest this. They have an absolute right to request this under the rules 296 and 297. Judge Chupp has 20 days to issue a finding of fact and conclusion of law related to the ruling. So he may go ahead and do it for the whole thing or just the specific request that they made. That'll be up to Judge Chupp. But they do have the right to ask for this under the rules, and Judge Chupp must comply with it. And if he doesn't comply, they get to file another thing to get him to comply again. But let me be clear, this does not stop the appeal process. It's a final ruling on the merits. It's done. It's a final judgment, final order, and the appeal goes on at this point. So Jay Sean will be hoping, and this won't be a problem. Judge Chupp has 20 days. So Vic will have to file his appeal brief. Jay Sean will have to file an appeal response, and he'll have 30 days from the appeal brief. So he'll have plenty of time to get out of Judge Chupp this finding of fact and conclusions of law. But so it doesn't stop anything. It's do the rules that Lemoyne cites actually kind of discourage putting the findings of fact and conclusions of law into the ruling itself? No. They just allow you to get the judge's ruling. A lot of rulings don't need findings of fact and conclusions of law, right? Like, so-and-so took my bike and threw it off a cliff. You're suing them for $1,000 because it was a specialty bike. They don't need to. The court finds that the other defendant harmed this person by damaging their property, and the amount is $1,000. They don't need to go through a factual list of all the things that led up to the bike tossing to do that, right? Lots of rulings do not need finding of fact or conclusions of law, but the rules exist to allow you to, if you need an explanation as to why it happened, typically so you can take that explanation to a higher court and say that it's wrong. That's what they're there for. So just know that, well, Monica and Ron might be billed for this. We'll see how, with the way Lemoyne does his billing, this is probably 2 hours of research and then a half hour of drafting. I don't know. But he might not be billing for this. And if he is billing for this, they will kill him when they find out that he is. But it is funny to think that this extra work, all this extra work is way outside the TCPA order. So he's either not going to get paid for it or Monica will pay them, and that's funny. Okay. So this was filed yesterday so this was filed at 9:26 a.m. and the judgment came out about 12:30 p.m. So noon 30 Central Time. So this was filed in the morning prior to the judgment. And this is Monica Rial and Ron Toye's post-hearing brief in support of sanctions and attorney's fees. So this is they totally confident in how the hearing went, filed a supplemental brief to remind the judge of all the things that they definitely won at that hearing. CE says, just got off work. What's this? These are the documents related to the fees that we haven't gotten to yet. Because the fee hearing and judgment happened in very quick succession. And I didn't do shows over the weekend to cover the documents that were in the intermission time there. So we've got the post-hearing brief in support of sanctions and attorney's fees. So they were so confident in how that hearing went, they felt the need to supplement the record with another brief to really solidify all of the arguments that Chupp probably just ignored, which is great. Great. 19 pages. This took a couple hours. This is also outside the scope of the order, which means that somebody's paying for it. Joshua Gauss says, first, super chat. Hey, thank you, buddy. Love your show and all the memes. Really butter my biscuits. It would be amazing if the GoFundMe had an option to donate $8 per month to show support for Vic instead of Funimation. Keep up the good fight, Boomer. GoFundMe does have a recurring payment option, but it doesn't display it on the page, and that would be beautiful. I agree, but and I don't know how you activate it. But since you mentioned the GoFundMe, let's take a peek here. We've got $263,662. We've got Jordan Genesis, Stacy Dealeman, Manny Alvarez, and Anonymous. Thank you guys for donating. I really, really appreciate it. That was fantastic. Always fantastic. You guys just exceed expectations every time I bring up GoFundMe. Oh, and it pisses them off. I wonder if we're going to hear about the GoFundMe in this supplemental brief. Defendants Monica Rial and Ronald Toye, the moving defendants, submit their post-hearing brief in support of sanctions and attorney's fees as follows. Argument and authorities. The court should not consider issues raised in plaintiff's response, but not raised at the evidentiary hearing. Aww. Now, we haven't read those responses. I've got them. And we might get to one of them today. But there are 3 responses and a motion to strike. So we've got all of that. Plaintiff's response asserts we got a footnote. On the eve of November 21st evidentiary hearing, plaintiff filed his response and objections to Monica Rial and Ron Toye's brief in support of sanctions and attorney's fees pursuant to TCPA. Okay. Plaintiff's response asserts a number of issues that were neither raised on November 21st, nor was evidence introduced into the record to support such issues. Footnote 2. See interest of DZ. However, Mother's previous attorney did not testify about her attorney's fees at the hearing, and the trial court did not admit Mother's attorney's affidavit or billing records. Mother instead presented her own testimony about the total amount of attorney's fees she paid with a general description of her previous attorney's services. Mother's evidence lacks the substance required to uphold a fee award, and thus is legally insufficient. This is another one of those where I don't even have to read this case. I can just read that quote and know that it does not say what they're saying. Not at all. They're talking about stuff not being entered into the record. Well, filing it is entering it into the record. For one thing, they're also talking about someone attempting to get attorney's fees, not fighting against attorney's fees. And, they can make the comparison, but it's not, this is not an on-point case. It's also unpublished here. This is a Westlaw publication. Unpublished opinions. Maybe it's pending publication. I'm not sure. Sometimes unpublished cases have to be, well, in Minnesota, if you try and bring an unpublished case into a courtroom, you have to give like a 7-day lead time, and give the case to the other party. Since it's unpublished, you have to give them an opportunity to review something they might not otherwise uncover in regular research. I don't know if the Texans have a rule on that or not. By way of example, plaintiff purports that the court should apply the rates of Ty Beard and Jim Bullock, yet neither of them nor a qualified expert took the stand to defend their rates, their legal acumen, or their qualifications to opine on reasonable fees in a TCPA case. Plaintiff raised isolated time entries in his response, yet failed to ask any questions at the hearing on most of those issues. Plaintiff had several weeks to review and educate an expert, either from within the 2 firms and 6 attorneys listed on his response. Oh, look at how anally devastated they are over the amount of attorneys Vic has. They can't stop bringing it up. I thought I pissed him off, but the number of attorneys just keeps popping up. They have 4 attorneys at a hearing. They have 6 attorneys listed on the response. So? To create his own lodestar and submit that evidence to the court as a counterpoint to the moving defendant's evidence. Simply put, the court cannot accept assertions that have no evidentiary support in the record. Moving defendants followed the analysis of Estate of Stokes and McGibney versus Rauhauser to ensure a proper predicate for attorney's fees recovery exists. The predicate for recovering attorney's fees is the plain language of the statute that says you recover attorney's fees, you idiot. Plaintiff's reliance on Estate of Stokes is curious because there the trial court had a battle of experts as to the appropriate amount of attorney's fees under the Lodestar method. The Fort Worth... we've got a footnote. On remand, the trial court conducted a 3-day bench trial on the issuing of attorney's fees. Almost all the fee testimony was from each side's expert. One issue that was disputed throughout the trial was whether the Lodestar method applied to the entire attorney's fee award under Section 74.351. The Fort Worth Court of Appeals remanded because of the recent issuance of Rormu's Venture, which that's just a citation in that footnote. To avoid a similar remand, moving defendants analyzed and applied Rormu's Venture, including applying a billing judgment reduction of $30,686.45. See Defendants Exhibit 3 and 7A. Moreover, and unlike Estate of Stokes, plaintiff proffered no expert on attorney's fees to challenge moving defendants' Lodestar calculation as to rates or amounts of hours expended. And you still lost. And you still lost bad. That must suck. Plaintiff's reliance on McGibney versus Rauhauser, which moving defendants cited in their November 4th, 2019 briefing, is misplaced. First, because redactions were an issue in McGibney. Moving defendants tendered unredacted copies to the court for an appropriate determination as to any redaction. But you didn't provide it to the other party who would get to argue against the redaction or reduction as or argue for reductions of improper things. You didn't do it. And you actively fought it. Second, because the Court of Appeals expressed concern about the inclusion of items unrelated to the TCPA motion in McGibney, moving defendants reduced the Lodestar by reducing or excluding multiple hours from the Lodestar that could fall into such category. Aw, that's too bad. Third, McGibney involved a dispute where the plaintiff immediately non-suited his claim, which is completely inapposite to this case, where plaintiff pressed forward with multiple depositions, hearings, and filings. Compare McGibney with the docket sheet. That has nothing to do with whether or not you should recover attorney's fees. Unless you're saying you don't recover attorney's fees because you didn't incur any because you non-suited the claim in an attempt to reduce the cost. Something like that. Moving defendants faced a more complex fact pattern than Miss Markey or Funimation. Oh, here we go. Why? Why is that? Here is where he's going to argue that they're totally not in a conspiracy, even though they are. While plaintiff may have pled the same cause of action against all the defendants, the moving defendants were clearly the target of plaintiff's ire. Oh, were they? Given the unequal number of factual allegations against them as compared to Funimation Productions and Jamie Markey. No, there's just a different amount of defamation that your clients did versus the other ones. It's not about being the target of plaintiff's ire. It's about you gave them more evidence to do. The following table identifies the vast difference between the factual allegations that moving defendants needed to address as compared to their co-defendants. Yeah, because it's that they definitely went into the vast amount of that actually happened. Yeah. They definitely covered the vast amount of allegation differences that occurred in their filings and their hearings. None of that actually occurred. There are 400 tweets or whatever, and they didn't ever address any of them in any of their filings. So to assert this is ludicrous. Let's see. Footnote 5 says McGibney presented the highly unusual situation where the defendant filed a TCPA motion before he was served, while knowing plaintiff intended to non-suit the lawsuit, and thus did not have to appear in the case. Plaintiff immediately non-suited the case within hours of the TCPA filing, and the trial court made zero reductions to the full amount sought by the defendant. That's because That's because the plaintiff non-suited the case in an attempt to avoid attorney's fees being awarded against him. That's why they awarded the total amount. I don't really know what what either side has used that case for, but that's clearly what happened. And then attached here too as Exhibit A is a chart from the first amended petition. Oh, good. Remind the court that there's a bunch of evidence on the record that supports the defamation and TI. The original petition was introduced as Defendant's Exhibit 8 and factually tracks the first amended petition with few exceptions. Not only are the moving defendants two separate people, they're the only defendants deposed. Yeah, the others filed prior to depositions being able to occur. The only defendants that answered discovery incompletely and were inarguably the primary target of the lawsuit. And neither of those things are the plaintiff's fault. The defendants chose to accept deposition and chose to answer discovery. They could have filed their TCPA prior to doing either. Funimation filed their TCPA prior to responding to discovery. So did Jamie Markey. Court can also review the billing records and motion to dismiss to determine that it was only the moving defendants that secured 16 affidavits in support of their motion to dismiss, including the affidavits of 5 women that were assaulted by plaintiff. Look what they're trying to do here. And 3 convention owner directors that confirmed the moving defendants had nothing to do with the termination of plaintiff's invitation to those conventions. Footnote 7 is just going to be the lack of interference with the 11 conventions is something that Mr. Mignogna had no admissible evidence of when the lawsuit was filed on April 18th, on July 12th when he filed the first amended petition, or August 30th when he signed his affidavit. But the moving defendants had to defend against those allegations regardless. What did you have to defend? Just say he had no evidence. It was his burden. It's not actually your burden to contravene the evidence. This is where Lemoyne is being very slippery. Those affidavits didn't play into the decision. They couldn't. They can't. Because at the prima facie level, you're not allowed to controvert the evidence with other evidence. The facts asserted and the evidence asserted must be taken as true and favorable to the plaintiff in a proper TCPA. That's how it goes. That's how it is. The non-moving party gets benefits. That didn't happen in this case, but that's how it's supposed to happen. And as an expert, Lemoyne should know that his affidavits cannot possibly refute the testimony of Vic. Plus, you just admitted that only 8 of those affidavits had any merit to them. So why'd you get 16? As an example, the following table demonstrates the difference in work between what Miss Rial and Miss Toye addressed and what Miss Markey addressed. But you didn't have to do any of it. It was his burden. You could have just filed your TCPA. A comparison of the time records and Miss Rial and Mr. Toye's motion to dismiss, 28 pages with 12 affidavits, 2 declarations, 3 depositions, and 2 affirmative defenses, and supplement to motion to dismiss 6 pages with 4 affidavits and 2 affidavits with the time records, and Miss Markey's motion to dismiss 17 pages, 1 declaration, 1 deposition, no affirmative defenses, reflects the complexity of allegations in the first amended petition against the 3 different defendants. See, he's leaving out though that Markey's attorney and Funimation's attorney all attended the depositions, participated in the depositions, attended all 3 for the full amount of time, participated in Vic's deposition as well. But attending and participating is the same amount of time at deposition. They incurred significant costs because of Markey or Monica and Toye. Here we go. Miss Markey's work product cannot set the ceiling for attorney's fees because that work product does not even cover 1/4 of the foundation of the allegations in the first amended petition. He knew it was coming. He knew it was coming. Judge Shupp, this hearing went so bad for them. Look, this hearing went so bad that Lemoyne went to bed the entire weekend knowing that Chupp was going to award Johnson's attorney's fees to every defendant. That's how bad. That's how bad this went for them. He had to spend 3 days knowing that he was going to get cut. The real question was, Lemoyne probably thought he was going to get 50 as opposed to 100. Which, might I remind the court, what Lemoyne's response to this is? May it please the court, here's Lemoyne's response. When I announced that I'd be doing stream yesterday, and my intern tweets it out, they'll be doing Nick and Ty will be doing a show tonight. Your only hope. Don't do it. Just ignore it. Just ignore it. Lemoyne went to bed every night knowing this ruling was coming, fearing this ruling was coming, and then having his fears realized like an angry swarm of mosquitoes staring at him, just hanging on the... Did you guys ever see the birds, right? When they're all just crashing into the windows over and over? That's what Lemoyne heard, except it sounded like a silenced machine gun, right? Bunch of mosquitoes just pelting into the windows over and over. That's what he woke up to every day. And then finally it breaks through and that's the ruling. And he just got it. It just hit him. It just hit him. Hit him like the realization that his malaria net had holes. The work product does not even conquer 1/4 of the foundation of the allegations in the first amended petition. All allegations that you didn't need to address, actually. That's the funny thing. You didn't even need to address them. Even with Chupp's incorrect hearing, you didn't need to address them. But if Chupp had done the hearing correctly, you wouldn't have needed to address them. One final point raised by plaintiff drives home the difference between Ms. Rial and Mr. Toye and Ms. Markey when he asserts counsel for co-defendant Jamie Markey only required 2.5 hours to prepare for 3 depositions. Why would Ms. Markey's attorney spend multiple hours preparing for Ms. Rial and Mr. Toye's depositions when he's not going to ask them any questions? Maybe because he wants to be thorough. I don't know. Maybe he has to determine if he wants to throw them under the bus. Maybe because you're co-defendants, but you're not co-parties. You're not joint defendants. You're co-defendants. Notably, plaintiff's counsel did not raise with the undersigned the difference between moving defendants' incurred fees and Ms. Markey's incurred fees. They didn't need to. You needed to justify your fees more than they needed to dismiss your fees. Mr. Johnson had no need to spend multiple hours preparing for plaintiff's deposition when his client is referenced a grand total of 4 times and is being sued for defamation based on one tweet that does not even mention plaintiff. Maybe he didn't prepare for it because you told him you would take lead and you showed him roughly what you would ask. Because we saw that there were meetings between you and your co-defendant counsels all over the place in your billing. Maybe you didn't need that much time to prepare because you showed him what your questions were going to be like, or you told him that you would take over and ask most of the stuff and you would do all the nasty bits, right? You would attack the character of the witness over and over and over again while they could come in and just kind of sweep up on their issues. Maybe you volunteered for that. Otherwise, he would have had to prepare. Prepare for the possibility, and he probably still did, prepare for the possibility that you'd screw up. I know I would prepare for the possibility that you'd screw up. As being sued for defamation based on one tweet that does not even mention plaintiff. It actually does, but the tweet that she's sued for actually does mention plaintiff, and she's being sued for something like 3 or 4 tweets, I don't remember, but one that specifically mentions him and has factual allegations, and maybe the reason that gets overturned on her. This is also evidenced by the minimal amount of time he had to spend asking plaintiffs questions in his deposition about the one tweet plaintiff sued Miss Markey over. But again, it's more than one tweet. Plaintiff's complete deposition is attached to Ms. Rial and Mr. Toye's motion to dismiss. Mr. Lemoyne's questioning covered pages 10 to 234, while Mr. Johnson covered pages 235 to 264. He still did 30 pages. Oh my God. Ms. Rial and Mr. Toye were the primary target of the lawsuit and defended it accordingly. Their request for fees is not out of line with fees awarded 2 years ago in Rich versus Range Res Corp. $470,000 in attorney's fees awarded by the trial court. I don't know anything about this case. I don't care. Block billing is allowed under Texas law. Plaintiff asserts that block billing is not allowed under Texas law by attempting to extrapolate Rormu's venture and citing Barrow versus Greenville Independent School District. See plaintiff's response, paragraph 10. First, Rormu's does not use the word block, does not reference block billing, and did not adopt the entirety of federal court jurisprudence with regard to attorney's fees calculations. Second, while neither the Texas Supreme Court or Fort Worth Court of Appeals have addressed the issue, Houston Court of Appeals rejected the assertion that Texas law is adverse to block billing. See State Farm Lloyds versus Hansen. Third, even assuming a block billing reduction is required. Oh, wait, we've got essentially State Farm argues that L Apple requires assigning a particular number of minutes to each individual task. We cannot agree that such level of detail is required to be able to meaningfully review a fee award. Yeah, I have no idea about that case. I don't really care. Third, even assuming a block billing reduction is required, and it is not, Barrow, the case cited by plaintiff, stands for the proposition that between 10 and 20% is appropriate, as opposed to the 80% sought by plaintiff. To the extent plaintiff wished to challenge, that must be a 10 to 20% reduction, whereas the plaintiff is asking for an 80% reduction. To the extent plaintiff wished to challenge block billing and seek a reduction, it had an obligation to articulate those line items for which a reduction is necessary through cross-examination and or its own expert testimony as to the reasonableness of time expended. Notice here, you can always tell when Lemoyne's making shit up again, because he doesn't include a citation. Lemoyne includes lots of citations, which is good. He's an expert with probably pretty good memory about where to find a lot of this stuff. If we take him at his word that he's an expert, he's going to know roughly where these citations are that he's going to be using, because he'll probably be using them in other cases. He doesn't have one here. So he's made this up. And you'll find that here and there. He leaves out citations on very important conclusions that he makes. Conclusion and prayer. For these reasons, moving defendants request the court enter a final judgment that awards reasonable attorney's fees, expenses, and costs. Enter a sanction against plaintiff sufficient to determine the amount chosen by court, but between a range of $100,000 to $260,000. Such other and further relief. Well, and we saw how that went, right? They got $100K, basically capped at Jamie Markey's amount, or well, just over Jamie Markey's amount, capped at $50K a defendant, is what it looks like, although it doesn't say that. And that's an interesting move by Judge Chuck. He could have broken it out and awarded attorney's fees based on them separately as two different people, but he didn't, which leaves the flexibility to say it was $50K a defendant, but also the flexibility to say it was $100K for this attorney and $50K for the others. Lemoyne just articulated an argument that justifies him getting twice as much as the other people, right? So there you go. Chuck can go through this and say, you didn't get the same amount as the other people. You got twice as much based on the amount of work you needed to do. There you go. You can agree with every single proposition in here and determine that the fees are still reasonable because he gave him twice as much. So then we got Exhibit A. This is great. Mignogna petition allegations. So here we go. Here's allegations. This is for the purpose of the TCPA. This is in the first amended petition. This is a petition that's included. And for the purposes of TCPA, this is evidence. And these assertions are required to be taken as true. I can't stress that enough. That's how prima facie works. And these are in the petition, so they are evidence by definition. So he just goes ahead and puts it back in there. January 16th, Broly released. Monica liked and retweeted the tweet of someone with the Twitter handle Hanleia that accused Vic of being a homophobic, rude a-hole who's been creepy to underage female fans for over 10 years. They liked and retweeted 2 tweets by Kaylin Saucedo. Accused Vic of great volumes of sexual misconduct. Urged Funimation, that's defamation per se. Urged Funimation to reconsider hiring Vic Mignogna as a voice actor in the future. If that's defamatory and hey, if this is defamatory and it is false and defamatory, then this following line is tortious interference with prospective business relations. I mean, by definition, whether it practically works out that way, which means that liking and retweeting those could be considered that. It could. Chup actually even agreed at the TCPA that retweeting something could put someone on the hook for the damage caused by those statements. They could actually bring that to the appeals court. They could bring that to the appeals court and say, the judge even agreed that retweeting something could put you on the hook for the damage caused by the statement because you're republishing it, you're saying it, you're asserting it. The judge agreed with that. And he agreed that words online can cause harm. All you have to do is determine that this, if taken as true, is defamatory or is possibly defamatory, that is prima facie defamatory. It is. And that passes TCPA right there. I hate pointing this out over and over. But these guys are verifying it. Repeated attention that Monica, Jamie, and other agents caused their tweets to go viral. About the same time, one or more defendants began actively defaming Vic directly to anime conventions. Speaking of investigations of Vic being fired. Again, this is evidence right here. And if taken as true, this is specific. This is clear and specific evidence. One or more defendants began actively defaming Vic directly to anime conventions. Speaking of investigations and Vic being fired. There you go. Clear and specific evidence of an act. Barely a week later, Tammy Dembo. Okay, I'm not going to go through all of this stuff. Here's Jamie Markey. Oh, wait. I want to do... So Vic's a sexual predator. And these are referencing tweets. Here's Jamie Markey's specific tweet. It happened to me. And this is her responding to Monica Rial's tweet. It happened to me. I'm only one voice in a sea of many. Well, you're one whale in a sea of many. He's hurt enough people. He's a sick man and needs help. Later that day, Jamie attempted to rebuff those questioning the veracity of Monica's posts. Funimation made its investigation public. Here's the Funimation tweets. Monica Rial says he's the legal definition of harassment. Here, Monica's posts about the investigations. Here's a lengthy post. These are, again, if you try and argue, despite the plain language of the law, that this isn't evidence, this words from the tweet definitely is. I can't overstate this. People keep saying that this evidence wasn't brought up. It absolutely was brought up. It absolutely was. It's in the record. And here they are admitting that it's in the record. Wife beater Ron Toye, all of his crap. First amended petition. Here's Jamie again. And here's Jamie Markey. So here we go. Here's reference to Jamie Markey's tweet. Jamie tweeted that Vic had assaulted her several years prior by grabbing her hair and whispering in her ear that what he whispered she couldn't remember. That in the last week or so, I've heard accounts of him doing this exact thing to over a dozen women that I personally know. By the way, let me be very clear on something. Assaulting her, saying that Vic assaulted her by grabbing her hair and whispering into her ear. Grabbing her hair and whispering into her ear. These are factual statements that are demonstrable, that can be proven true or false given all knowledge. Did he grab her hair and did he whisper in her ear? Defamation. Period. Prima facie case of defamation. There's no arguing against that. That's what it is. Chupped up on this. But this is also defamation, and there's a whole case on it that's cited. Kahn versus Vanderlinden. I've heard accounts of him doing this exact same thing to half a dozen other women that I personally know. I've heard accounts of him. If false, is a defamatory statement. And at TCPA, prima facie, this must be taken as false if asserted as false. So here's yet another. This is, if you knew, Jamie Markey knows if half a dozen women, if she's actually heard accounts of him doing this exact thing, the exact thing to half a dozen other women. Those are provable statements. Jamie Markey either did or didn't hear them, and it either was or wasn't the exact thing. Vanderlinden versus Khan was not about whether or not the guy actually gave money to a terrorist organization. Vanderlinden versus Khan was about whether or not the guy told someone he gave money to a terrorist organization. The telling was provably true or provably false. Same thing here. Funimation. Okay, so anyway, this is all in the record. That's why I wanted to bring this up. This is here. And they are just reminding the court that it's in the record. So good job. And on appeals, they'll bring it up. Look, it's in the record here, here, here. They even affirm it's in the record post-judgment here. Or pre-judgment. This is prior to the final ruling. So you can't even argue that this shouldn't be included because it's after the ruling. They included it in the record prior to the final ruling on the merits. There you go. Is it going to be in the record for appeals? Should be. I mean, it already is. But they can say, look, they've affirmed this is in the record. It's in their own filings. They don't deny this stuff. What more evidence do we need that he has a prima facie case? All right, next. Next. Oh, man. Sign in again, just a second. It signed me out. Upgrade. Let's see, purchases. Here we go. I didn't download the others. Oh, come on, it doesn't tell me what... Oh, wait, that's the order number. Perfect. I thought it didn't tell me what individual documents there were. All right, let's go with... Since we're on a Monica and Toye kick, let's go with the plaintiff's response to Monica and Toye. I have a feeling these are probably going to be very similar for the three parties. But I don't know. I haven't had time to read them yet. Here we go. Save. Whew, it is hot in this room, guys. Ha. Should be in shorts. It's cold outside, but it's hot in here. Where's Nelly when I need him? Okay, so this is the plaintiff's response and objections to Monica Rial and Ron Toye's brief in support of sanctions and attorney's fees pursuant to the TCPA. Now, this is their first brief. This is not that supplemental brief that we just read. We're going back in time. This is the way you really do legal documents, is you go backwards through them. It's messy. It's not Nelly, that's R. Kelly. Oh, well, at least I'm going to cool off with some refreshing, with a refreshing shower. So it's fine. Mr. Clark says, hey, Nick, I'm back again. I failed to get the funds for editing for my novel, but I haven't given up. I have someone who's willing to do it far cheaper. Here's my YouTube. If I get to 1,000 subs, I'll eat the Reaper on stream. Let me get your YouTube in the chat here. Your YouTube channel. All right, chat. If this guy gets to 1,000 subs, he'll eat a Reaper pepper on stream. Hopefully, he will live through it. Hot in here is definitely Nelly, guys. Don't even mess with me. I demonstrated yesterday that I know my rap music. I am well versed in urbanity. In youthful urbanity. I know my rap music. How dare you? I know hot in here is Nelly. Don't you dare question my black cred. But if R. Kelly were coming, like I said, I'd get doused and cool off very quickly, which would be nice. Although I feel like the dousing might be 98 degrees. 98.6 degrees. Maybe there's a little cool off from the time it leaves the vessel to the time it covers my body. Broken link? It's a broken link. Mr. Clark. Is it broken for me? UA, NBA, JCOT. That's a broken link, man. I don't know what to do. Sorry. I don't know how to help you. I didn't boomer the link. That's exactly the link he sent me. I copied it directly from there. So I don't know how to send me an email or something, maybe? I don't know. Now comes plaintiff Vic Mignogna and files his plaintiff's response to Monica Rial and Ron Toy's brief in support of sanctions and attorney's fees pursuant to the TCPA. In support thereof, plaintiff would respectfully show the following. It says, I saw your DM. That's not my... It's not my link. I copied the link from the Streamlab chat. I can't do anything to fix that. It's Streamlabs doesn't even let you copy and paste, okay? When there's a link, you literally grab the link and drag it. There's no way I could screw it up. It's impossible. Let's see. Yeah, that's not it. Okay. Yeah. Plaintiff asks the court to deny defendants Monica Rial's and Ron Toye's defendants' request for attorney's fees regarding the attorney's fees that are in excess of a reasonable attorney's fee. Plaintiff asks the court to deny defendant's request for additional sanctions against plaintiff because such a sanction is not necessary to deter plaintiff from bringing similar actions. Further, the defendants seek these sanctions only to punish plaintiff for his public participation. Additionally, plaintiff opposes and objects to several billing entries for costs and attorney's fees offered by defendants in support of defendant's brief in support of sanctions and attorney's fees pursuant to the TCPA as detailed further herein. Defendant's billing entries include block billing, overstated time charges, excessive attorney rates, excessive attorney conferences, duplication of efforts and overstaffing, and fees for efforts in seeking improper relief. Woo! Let's see. Response to request for attorney's fees. Plaintiff opposes defendant's request for attorney's fees and costs on the grounds that the fees and costs are in excess of a reasonable amount. TCPA requires an award of only reasonable attorney's fees. A reasonable attorney's fee is one that is not excessive or extreme, but rather moderate or fair. Of fair. I think it's supposed to be or fair. See Sullivan versus Abraham. Abraham's an old dude. He's been around a long time. Determination of what constitutes a reasonable attorney's fee involves two steps. First, the court must determine the reasonable hours spent by counsel in the case and a reasonable hourly rate for such work. El Apple 1 Ltd versus Olivas and Dinkins versus Calhoun. Citing El Apple and finding that where there was no evidence regarding the Anderson factors, other than the time spent and hourly rate, the evidence was legally insufficient to support the amount awarded by the trial court. The court then multiplies the number of such hours by the applicable rate, the product of which is the base fee or lodestar. The court may then adjust the base lodestar up or down, apply a multiplier, if relevant factors indicate an adjustment is necessary to reach a reasonable fee in the case. The relevant factors when determining a reasonable attorney's fee are provided in Arthur Anderson versus Perry Equipment. Those factors are, these are the Anderson factors they were mentioning. NixX, I will find your NP2 email. I see it. I see you, girl, and I will find it and make sure you get an invite. Okay, these are the Anderson factors. The time and labor required, the novelty and difficulty of the questions involved, and the skill required to perform the legal service properly. The likelihood that the acceptance of a particular employment will preclude other employment by the lawyer. The fee customarily charged in the locality for similar legal services. So number 2 there is, if the lawyer takes on this case, will it prevent him from taking on other cases? Number 4, the amount involved and the results obtained. Number 5, the time limitations imposed by the client or by the circumstances. Number 6, the nature and length of the professional relationship with the client. Number 7, the experience, reputation, ability of the lawyer or lawyers performing the services. And 8, whether the fee is fixed or contingent on results obtained or uncertainty of collection before the legal services have been rendered. Do you guys realize that Sean Lemoyne probably promised Monica and Ron that he would get all of their fees returned and then ended up getting 35% of them awarded to him? Was it 38%? God, that sucks. That's embarrassing. The movement seeking attorney's fees bears the initial burden of submitting adequate documentation of the hours expended and hourly rates. Hensley versus Eckerhart. The applicant should exercise billing judgment with respect to hours worked and should maintain billing time records in a manner that will enable a reviewing court to identify distinct claims. A party seeking attorney fees is charged with the burden of showing the reasonableness of the hours billed, and therefore is also charged with proving that they exercise billing judgment. Notice, when they're making these definitive statements about what the attorney's fees are, they have a citation on all of them. Sison versus Delta Concrete Products Corporate Company Incorporated. Court must review billing records and exclude all time that is excessive, duplicative, or inadequately documented. That's Hensley versus Eckerhart. Quote, the hours surviving this vetting process are those reasonably expended on the litigation, citing Watkins versus Fortis. Quote, billing judgment requires documentation of the hours charged and of the hours written off as unproductive, excessive, or redundant, citing Sison. The proper remedy for omitting evidence of billing judgment does not include a denial of fees, but rather a reduction of the award by a percentage intended to substitute for the exercise of billing judgment. Okay. Cemetery Lady. I know a ton about ICP. I used to listen to ICP. Ringmaster, Riddlebox, and Great Malenko. Those 3 albums in particular, I listened to them a ton in high school. Hilarious. They still run through my head from time to time. In a state of Stokes, the Fort Worth Court of Appeals noted what is reasonable is the same as what is reasonable and necessary. There, the court considered a defendant physician's reward of attorney's fees, which were reduced from over $100,000 to $44,335 following a 3-day bench trial, in light of the fact that the physician pursued discovery on the merits of his case rather than diligently pursuing dismissal pursuant to the Texas Medical Liability Act. You can hear the smile in my voice, and I'm gonna point out exactly why in just a second. When plaintiff failed to comply with the requirement for a timely expert report, the state of Stokes. Okay. This is deep lore in this case. The fact that Martinez Sue pulled out this particular quote from this particular citation is great. Okay? Here's why. Remember, I criticized Chupp for his citation in his order, because the citation cited a law review journal that was discussing the new TCPA. Stick with me here. His citation was citing a law review article that was discussing the new TCPA and it was comparing the new TCPA to a law that was not the TCPA. It was trying to say that the TCPA should be applied in this way because it's actually applied in the same way to a different law, okay? Trivia, it was the Texas Medical Liability Act. That's the law that the law professors in the article that Judge Chupp cited were referencing and trying to mirror that onto the TCPA. So Judge Chupp used a citation to the Texas Medical Liability Act for early dismissal as similar enough to the TCPA. Martinez and Sue found a case where the Texas Medical Liability Act is used. They use the same comparison that Judge Chupp used. And I would bet money that that was intentional, and that is phenomenal. That is a phenomenal exercise of knowledge of the case and of like how, Judge, this is your reasoning exactly. And if we're going to apply your reasoning here, we should apply it here. Brilliant move. This, and it's funny that Lemoyne doesn't get it. I didn't get it until I read exactly what they're arguing. If Chupp paid any attention to his own citation, I bet he did. He knows that that's what that was referencing. That's great. That's great. While that case was remanded for determination in accordance with Rormu's venture, it confirms the rule that unnecessary attorney's fees, those which do not further the party's case, are not reasonable under the lodestar method. This applies here where defendant pursues a strategy of monitoring and attacking public statements made by plaintiff and non-parties and seeks sanctions as a means of silencing plaintiff. Oh, brutal. Lemoyne, you done chopped up? You chopped up? In other words, the defendants seek to recover attorney's fees for their endeavor to deter plaintiff from his own public participation, rather than offering any evidence that shows additional sanctions are necessary to sufficiently deter plaintiff from bringing similar actions described in the TCPA. And the best part is, the plaintiff wasn't even participating publicly and could claim that he was silenced by the defendants. Defendant's billing should be reduced by 80%, due mostly to gross overbilling, billing for unnecessary tasks, and improper block billing. Monica, Ron, gling, 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 gling. Not only do you have an attorney warning you about you getting fisted on billing, you have a judge confirming it. Malpractice. Malpractice. Monica and Ron, are you listening? You have an attorney alleging improper billing against you by your counsel. And the judge agreed. And wait till that finding of fact and conclusions of law. That could be the funniest part. If the findings of fact and conclusions of law, if Chupp is pissed off enough, he could go ahead and put word the finding of fact and conclusions of law in a way that absolutely gives Monica and Ron a direct lawsuit against Lemoyne for malpractice. That would be premium troll judge. Defendant's billing entries include block billing. That is, the billing entries do not specify the amount of time spent on discrete tasks. When time records are block billed, the court cannot accurately determine the number of hours spent on any specific task, and the court is thus hindered in determining whether the hours billed are reasonable. Without detail about the work done, how much time was spent on the individual tasks, and how an attorney arrived at his proposed sum, an attorney's testimony lacks the substance required to uphold a fee award. Rormu's venture. Citing Rormu's venture again. Embracing federal case law applying lodestar method of determining attorney's fees, finding insufficient evidence where attorney's testimony was too general to establish that the requested fees were reasonable and necessary, specifically failing to provide sufficient detail of the work done. See also Barrow versus Greenville Independent School District. In the Barrow case, the United States District Court for the Northern District of Texas analyzed attorney's fees involving block billing under the Anderson factors. There, because of block billing, it was, quote, impossible to conduct meaningful review and determine the precise number of hours that should be reduced in each time entry. Following an extensive review of the attorney's timesheets, the court reduced each attorney's bill by the percentage of items that were too vague to support an award of attorney's fees. Nearly every entry in defendants' billing records are block billing. They contain a string of several discrete tasks, provide no indication of how much time was spent on each discrete task, and provide a lump sum time entry. Such billing practice by defendants' attorneys is a clear and concerted effort to avoid scrutiny of their excessive bill of approximately $260,000. Now, I keep saying 280. That's because at the hearing, they asked for actually more than they asked for here, which we knew they would. We knew they would. I mentioned that they're going to include their other filings that were done and their other stuff and the appearance at the hearing and all of that. They're going to include that as additional fees. And they would have done so with Slaytosh's deposition as well. The excessive fees come as no surprise after Mr. Lemoyne stated his intention to, quote, go after the plaintiff's GoFundMe account, which holds a remarkably similar amount. Lemoyne, was that stupid of you? Defendants have conjured this figure for their fees and used block billings to hide their misdeeds. Oh, we have become French. Now we see the GoFundMe. We're at $263,785. Can we get to 264 tonight, ladies and gentlemen? Time will tell. Thank you to Lorenzo Martinez, Philip Kilroy, Cyan Azuma, Devin Cohen, Matt Mark. Hey, blessed with 2 first names. If you had a 3rd first name, you'd be a serial killer. Anonymous as well. Thank you all for your donations. Really appreciated. Wonder if we can get to $264,000 tonight. Here we go. Mr. Lemoyne's sole entry for July 2nd, 2019 demonstrates the egregiousness of defendant's block billing. The entry is for 7.8 hours at $515 per hour. No way on earth did that breathless wonder work for 7.8 hours out of a day. No way on earth. Guys, attorneys are just normal people. There's exceptional ones like Lemoyne, and there's good dudes, there's bad dudes. It doesn't matter. Who do you know who works for 7.8 hours in a day? Who works for it? Not who goes to work for 8 hours. Who works for 7.8 hours? I bet you know literally 0 people who have worked a 7.8 hour day, unless they're like a trucker or some job that requires your honest, constant attention. Most people, even like manufacturing jobs, they have breaks because they have to. This is not a criticism, and they deserve an 8-hour workday. Don't get me wrong. Don't get me wrong at all. But I believe the FTE, the full-time equivalent calculation for amount of work done for an 8-hour day is something like 5.35 hours. 5.35 hours for an actual 8-hour day. That's the amount of productive work. Because you got poop breaks. And trust me, if you're on a CNC machine, you better take a poop break during the day. You got smoke breaks. You got just I got to walk to a water fountain. Anything you do, people need a little bit of time of downtime. Our brains, we are so evolved past working hard during the day because we live in a society or whatever. We're so evolved past it. There's nobody. And let me tell you, a CNC operator works way harder than any attorney you've ever met. you've ever met. Don't let Ty fool you. Don't let anybody fool you. Any attorney who's like, oh yeah, I worked 8 full hours that day. Yeah, sure you did, pal. Sure you did. Let's call your service provider and find out the incognito time you spent on hentai, okay? Okay, anyway. Is described as confer with opposing counsel, prepare subpoenas, litigation hold, prepare motion for leave to conduct discovery, conduct legal research, re defamation, causation, consent, liable proof, and TCPA applications, re same. By reading this entry, the court cannot determine how much time was spent on each discrete task, whether it was reasonable, or in this instance, how many tasks are even described. Defendant's billing entries include tasks for unrelated matters. This is great. What morons included this in their billing? Defendant's supporting documentation is brimmed, I think it's brimming, with charges that do not relate to this case. In one particularly glaring example. Is this a glaring example? It's like the Eastwood. The defendants seek an award for their time their attorney, Mr. Eric, spent on, quote, a telephone chat with client regarding New York Bankruptcy Counsel's demand for settlement preference payments. Forward Excel spreadsheets to client to complete within a week. Emphasis added. No New York Bankruptcy Counsel is working on this case, nor does this case in any way involve settlement preference payments. Yet defendants' attorneys, in their supporting affidavits, swore under oath that these fees were reasonable and incurred for the purpose of defending against plaintiffs' claims. What idiots? What idiots would do that? Well, I mean, Casey Eric. Defendants provide no... is this Ty's response? This is Martinez Sue, I think, drafted this one. Probably Ryan Sellers is signed on it. It's their response to the initial motion, not the response to the supplemental brief we just read. This came before that supplemental brief. This was before the hearing, so just so you know. We're going back in time. Like Huey Lewis in the news, we're going to go back in time and talk about this. Defendants provide no explanation for why they chose to include several hours of discussions regarding death threats in their fees for this suit. To be clear, plaintiff is not accused of making death threats himself, nor encouraging that behavior in anyone else. Rather, defendants... By the way, have you guys seen Taylor Swift's drama? Scooter Braun had to beg her to stop sending her fans after him for all of the death threats he received. 81 million Twitter followers. Reminder, I got thrown off of Twitter for calling a fat girl fat. And calling a mutant a mutant. Taylor Swift turned 81 million people against Scooter Braun. She's fine. Specifically, Monica Rial, Rontoya, and Jamie Markey have repeatedly claimed they have received death threats. Oh, I love that they put it in quotes. Particularly prior to this lawsuit being filed by plaintiff. In the event the defendants have received death threats, plaintiff disapproves of any alleged threats and empathizes with his opponent's struggles. Snuggles in coping with division and animosity in the anime community because of the statements made by defendants. Oh, wrecked! But objects to paying their attorney's fees for talking about it on the phone for over 3 hours because this work is simply not related to this lawsuit. Court cannot sanction plaintiff for actions taken by anonymous strangers. Let me be clear. As Commander-in-Chief, I believe zero. Absolutely zero. Absolute zero. The least possible. That any death threat ever occurred. I think we can agree. Death threats are wrong. Bad for society. But I do not have the evidence or the trust to determine that a single death threat ever occurred in this case. Yeah. Absolutely. Do not believe a single... Remember, the one death threat that they actually reported to Homeland Security was a prank call, a documented prank call from a prank call website. one which I have received. I have received the exact same prank call, and when I got it, once I realized very quickly that it was a recording, cause I'm not a moron, Monica, you fucking moron. I'm not stupid. I'm not a dim-witted broad who can't figure out that when you talk to the thing, it has a pre-recorded message that doesn't interact with you. It takes about 10 seconds to figure it out, you dummy. Since I'm not stupid, I was able to discern very quickly that this was not a real person, but rather a recorded comment on the other line, and dismissed it as such because I'm not handicapped by a sub 70 IQ. I'm not handicapped by a cold storage level IQ like Monica Rial. Maybe a different ending goes after the re in Rial. I don't know. I guess I'm just too smart. Whereas in receiving the exact same prank call over a year prior to Monica receiving it, I figured it out within about 15 seconds. When I was like, sure, buddy, what's your beef here? And then they went on with their stupid message because it's a recording. These people. Defendants also seek billing for their attorney's efforts in digging up dirt to further smear plaintiff. Not only is this task clerical and not traditional attorney tasks, plaintiff's public statements are not relevant to any fact of consequence before the court. Defendants use plaintiff statements, third-party statements, and pictures from their internet research as exhibits purportedly supporting their request for sanctions. As discussed below, plaintiff cannot be sanctioned for other people's actions, nor can plaintiff be sanctioned for exercising his own rights to speak his opinion to the anime community and associate freely. Fees incurred in these pursuits are improvidently sought and should be denied. Again, interestingly, it's possible that they could TCPA the sanctions request by citing Vic's right to free speech if they had chosen to. The TCPA is broken because the sanctions and attorney's fees awarded under the TCPA might just render it into a legal action under the definitions of the TCPA, which would then make it subject to a TCPA depending on the specific circumstances, like arguing against the plaintiff's public participation. Guys, do you think Vic wants to speak in his defense? I bet Vic would love to talk to the anime community directly and just say, hey guys, this isn't true. You know, I want you to be support, you know, I want you to be kind. I want you to be nice and I want you to be, listen, I don't want the hate. I want the community to heal. I'm just here to spread positivity. I love positive people. I'm a positive person. And the anime community, well, it doesn't need to deal with the drama between a couple voice actors. So we need positive. Do you think Vic probably has wanted to say that? I bet Vic has desperately wanted to say something like that for the past, 10 months. But the problem is, if he said a word, these pieces of garbage would use that to say he was participating in his defense, making him a public figure, a limited purpose public figure. These scum have prevented his ability to speak directly about accusations that they made. They engineered a situation where he couldn't defend himself. This can be defendant's billing. Oh, wait, fees incurred in these pursuits are improvidently sought and should be denied. Defendant's billing entries include overstated time charges. Courts can reduce fees where there is evidence that a time entry is overstated. This can be the case where time entries for the same task are inconsistent in the amount of time, where a time entry for attending a deposition exceeded the length of the deposition. Hey, Andrea Perez, I'm pretty sure you lied about the length of time you attended a deposition. Or where the legal length of time a particular task took significantly more time for that task than the opposing attorney. citing Kiewit Offshore Services Ltd. Versus Dresser Rand Global Services. I don't remember if it was specifically Andrea, but I think it was. These deficiencies are self-evident in defendants' billing statements. During June, plaintiff and defendants' depositions were taken. Defendants' billing entries include over 50 hours in preparation alone for the depositions. The attorneys for plaintiff did not spend 50 hours preparing for the 2 separate depositions taken by plaintiff's attorneys. Sean Lemoyne was the only attorney from the defendant's legal team that asked questions of plaintiff during the deposition. Yet it took 50 hours for preparation to depose plaintiff only. Well, you know, I have to disagree with Martinez here. Have they heard how long it takes Lemoyne to get a sentence out? Did they factor in lung capacity? It just takes him longer. Takes him longer to talk. This is clear evidence that defendants have attempted to inflate their attorney fee award beyond the time that was spent. Defendants both testified at their deposition that they prepared for the deposition by speaking to an attorney on the telephone for only an hour or so. Counsel for co-defendant Jamie Markey only required 2.5 hours to prepare for 3 depositions. This practice, replete through defendants' billing, singularly justifies an 80% reduction. Notice Lemoyne focused on this part, just the 2.5 hours that Sam Johnson spent, and really quickly ignores the fact that his defendants perjured themselves. Right here. Doesn't want to. We don't want to talk about that. Defendants' billing entries include duplicative, excessive, and unnecessary attorney work. A court can reduce fees for duplicative or unnecessary or excessive attorney work, conferences, if they are unreasonable regarding the complexity of the issues being considered. Citing L. Apple 1, charges for duplicative, excessive, or inadequately documented work should be excluded. It should not be lost on the court that defendants are aligned with 2 other parties in this case. While defendants and their co-defendants have acted in concert with one another throughout every step of this litigation, the defendants are in essence represented by 3 legal teams who are all billing for identical and or similar work. For the month of September, and all of the defendants, all of them signed on in agreement with all of their co-defendants' filings. And that might have sunk you morons too. Treating this as a joint defense when it was single defenses. You have an obligation to represent your client, not other clients. You signed on to and agreed to every other defendant's thing after having conferences with them. Whoops. Whoops. Is that a good idea, Volney? Was that a good idea, Lemoyne? We're going to have an 8-hour conference lunch at the strip club. The male strip club. Let's see. For the month of September, defendants billed 21.5 hours of entries that involved emailing or conferencing, often with counsel for the co-defendants. Each of these defendants seek fees for months of conferencing among one another. To the extent that each defendant's legal teams needlessly duplicate tasks, or fees for such tasks are subject to significant reduction. Second, defendant's attorneys spend an excessive amount of time needlessly padding the bill. As discussed in paragraph 18, defendant's 50 hours of deposition preparation are facially false and clearly padded. Further, an entry by defendant's attorney EAM on October 14th, 2019 indicates that he spent 3.2 hours to, quote, review and revise attorney's fees. This entry alone clearly demonstrates that fees were added to the billing records provided to this court under penalty of perjury by defendant's counsel. The deposition is certainly not an isolated incident. On July 10th, 2019, Mr. Lemoyne charges 1.5 hours for sending a single email to plaintiff's counsel. But he hired the guy who wrote My Left Foot to do it. That's why. He could only type with his big toe on his left foot, and it took him a while to hammer out the email. To prepare pleadings and presentation on defendant's anti-SLAPP motion, defendant's counsel expended 260 hours. It's capitalized and bolded for a reason. To prepare pleadings and presentation on defendant's motion, defendants expended 260 hours. Preparing your pleadings? What, like 8 hours? maybe 16. Presentation prep. What? You're gonna go and you're gonna go in front of a judge for a 4-hour hearing. You're gonna prep what? 8 hours maybe? Maybe is justified. Or 32 hours. 260 hours. 260 hours. 60 hours would be ridiculous. Reminder that Lemoyne is an expert. And as he has stated on Twitter and in his own pleadings and everything, he is an expert who knows the TCPA back and forth. He has a blog on the TCPA, y'all. He has written about this. He can reference his own blog. He cites his own blog over and over and over again. This moron, he has the help of 90 plus online attorneys, and he required 260 hours to prepare what ended up being about 45 minutes of talking at a TCPA hearing, at which, like a proper cuck, watched other men argue over it. 260 hours. J. Sean Lemoyne's a liar. Wick Phillips as a firm is liar. And the judge acknowledged it. This is the law Twitter reasoning, by the way. Law Twitter reasoning suggests that Martinez and Sue called out Wick Phillips as a firm that lies about its billing, and a judge agreed. Case closed. Wick Phillips lies about its billing. Whew. Nearly all that time is spent on attorneys performing legal research and revising drafts. In one entry, defendant's attorney conducted a 10.4-hour strategy session. Pursuing strategy, I told y'all. Mr. Lemoyne's affidavit points out that he, prior to ever being involved in this case, has maintained a website blog specifically about anti-SLAPP laws, yet he and his team spent 260 hours to prepare a single motion to dismiss. Defendant's billing documents are full of tasks that were unnecessary if they were even performed at all. Third, defendant's attorney spent significant time giving undue attention to YouTube videos and other public statements in pursuing defendant's improper strategy of seeking sanctions as a means to punish plaintiff for exercising his First Amendment rights to free speech and association. As a matter of law, the court can only award those fees that were incurred as a necessity to defending the suit. Watching YouTube videos of people discussing the case does nothing to help resolve this lawsuit. As a matter of policy, the court should not award defendants their attorneys' efforts in attempting to silence plaintiff or other parties that support plaintiff. Monica and Ron, you smart people paid an attorney who knew that billing you for YouTube videos would not be recoverable at TCPA. J. Sean Lemoyne is an expert. He is the best TCPA lawyer in Dallas. He is the #1 guy. He knew for a fact that watching YouTube videos would not be recoverable. He lied to your face, and you gobbled up his dirty excretions. You idiots. You stupid idiots. But it's not your fault. He's an expert. You were told to hire him by Casey Eric, and was it Funimation? Did Funimation demand you hire him? Whoever was paying your bill, did they demand you hire him? You were told you're just innocent. I know. You're just dummies. You're just normal people who are dummies. That's okay. You got swindled by a grifter. You want the real grift? They took $170,000 of your money to watch me make fun of you. You want to know what's really funny? I bet there are emails making fun of you I bet they sent emails laughing. I bet someone on staff at Wick Phillips enjoyed one of the videos. Oh, God. Statistically speaking, they would. They would never admit it to you. But it'd be available on Discovery for that malpractice suit. They knew it! They knew it! They know that they can't recover for attorney's fees and they billed you anyway. They knew they could not recover for a YouTube video that Vic wasn't on and they billed you. They grifted you harder than I could dream of it. This is Fast and Furious. This is Gassed and Spurious 3. Tokyo Grift. They got you. Got them. They don't care about you. Lemoyne never has. Mosquitoes killed his ability to care about anything other than just breathing. He grifted your asses and you bought it like morons, but it's not your fault. It's not your fault. Lemoyne shouldn't have done it because he knows better. They know. They're a huge law firm. They know they can't recover on this. They lied to you and the court. Wick Phillips lies. Wick Phillips lies. They knew it. Of course he knows it. He's an expert. He told you he was going to get it all, didn't he? Didn't he? He told you every single dollar was coming back. It's okay if I watch these videos. Every dollar's coming back to you. Don't worry about it. Pay me now, bitch. Do you think attorneys don't know some of those fees aren't coming back? What did he tell you? I hope he told you. I hope he told you. Probably not gonna get fees for watching a video. Probably not. We could try, but it's probably not gonna. You're gonna have to pay for that. I don't want to watch this guy call me a lungless cuck over and over again. Did he actually tell you? That's all that matters in the world, is did he actually tell you? Because if he didn't tell you, oh boy, he's an expert. He's an expert. He sold you on being an expert, or he sold whoever's paying your bills on being an expert. I hope he told you. By the way, I'm adding the link to Mr. Clark's YouTube channel. He sent the updated one in the Streamlabs. So it's in the chat now if you want to check it out. If you want to check it out. Look, he may have told you. You may have consented to pay it because you're stupid. And if you consented to pay it, that's your own fault. Gotta love screw top whiskey. If you consented to pay it, that's your own fault. I can't help you. But if he didn't tell you, you got swindled by Wick Phillips. Wick Phillips lies. Hashtag Wick Phillips lies. Oh, God. Even a couple drinks in, that Game of Thrones whiskey is bad. Okay. The court in McGibney faced the issue of whether to bill for excessive opposition research and a troublesome pattern of heavy front-end loading of legal work might very well have been reasonable if the case had ever moved beyond the Chapter 27 dismissal stage, but was nevertheless premature and of questionable reasonableness at early stages of the lawsuit. Defendant's fee statements, in addition to duplicating work across 3 legal teams, demonstrates the same billing patterns as the attorney in McGibney. Unreasonable attorney time for researching plaintiff's public statements. Defendants are aligned in this case with 2 other defendants. In every step they take, they support and oppose the same motions and relief. Their arguments duplicate each other's on every issue. The research and evidence are nearly identical for every defendant. Defendants and their co-defendants' billing statements confirm this with documenting their often daily conferences with one another, presumably to ensure each is on the same page. Nonetheless, defendants and their 2 co-defendants claim to maintain 3 separate legal teams, each team with several attorneys, each conducting research, drafting, revising, attending conferences, and attending hearings. Lastly, defendant's attorney hourly rates, $435, $515, and $650, are each excessive under the Anderson factors, specifically because the tasks described and experience of the attorneys do not justify the high rates they are claiming. Ethan Minshall has been practicing law for 8 years and is billing at a rate of $435 per hour, an excessive rate based upon the number of years of his experience. Plaintiff's lead counsel Ty Beard and Jim Bullock have been licensed to practice law for 23 years and billed a rate of $400 and $350 per hour, respectively. Mr. Bullock maintains an office in the Dallas-Fort Worth area. Therefore, his rate is indicative of a reasonable hourly rate in Dallas-Fort Worth. Mr. J. Sean Lemoyne has been licensed to practice law for 19 years and is billing at a rate of $515 per hour. Jeff Mills has been licensed to practice law for 9 years, and Jeffrey Helberg has been licensed to practice law for 23 years, like Mr. Beard and Mr. Bullock. Neither Mills nor Helberg are a named partner in this law firm, like both Mr. Beard and Mr. Bullock, yet both bill at a rate of $650 per hour. Comparing the billing rates, this clearly demonstrates that the billing rate used by defendants' counsel are excessive. Considering the unreasonable charges self-evident in the defendant's billing statements, plaintiff asked the court to deny any award for charges that were not sufficiently documented and not reasonably incurred. Response to request for sanctions. In addition to seeking over $260,000 in attorney's fees and costs, defendant seeks a sanction award, quote, between a range of $100,000 to $260,000, $100,000 to $260,000 against plaintiff, allegedly, quote, to deter plaintiff from bringing similar lawsuits in the future. Plaintiff asked the court to deny defendant's outrageous request for sanctions in its entirety on the grounds that the award will not serve to deter plaintiff from filing similar lawsuits and because defendants seek to use sanctions to punish plaintiff for his own public participation. Defendant's purported reasons as to why this court should issue additional sanctions against plaintiff can be boiled down to 3 distinct points. 1, third parties are discussing the case in public discourse. Hi, Sean. A third party has raised funds supporting plaintiff's effort. Oh, that's me again. Oh, I'm so honored to accept this award. Let's take a look at the GoFundMe. We are up to $264,045. We did it, Reddit. We're over at $264. Thank you, guys. We've got donations from Jesse Fritz, Anonymous, Michael Gary Pierce, Tazmil Ramzan, Dominique Botempo. Thank you guys for donating since the last update. We have what, 8,000 donations. 8,000 donations from 5,700 donors. That means that a bunch of you, 2,300 of you roughly, have donated more than once. That's amazing. Absolutely amazing. Imagine if 5,700 people deleted their Funimation subscriptions. I don't know how many. I don't know how many people have. But imagine if it did. Okay. Here we go, back to it. And unsupported claims that plaintiff is vindictive. A trial court abuses its discretion if the sanctions awarded are greater than necessary to promote compliance. See Lowe versus Henry. The TCP citing the Lowe versus Henry has been cited by the defendant several times. The TCPA's purpose is to prevent the bringing of meritless lawsuits that discourage the exercise of certain constitutional rights. The court should consider the following non-exclusive list of factors. These are Lowe factors to the extent that they are relevant. Good faith or bad faith of the offender, degree of willfulness, vindictiveness, negligence, or frivolousness involved in the offense, the knowledge, experience, and expertise of the offender, any prior history of sanctionable conduct on part of the offender, the reasonableness and necessity of the out-of-pocket expenses incurred by the offended person as a result of the misconduct, the nature and extent of prejudice apart from out-of-pocket expenses suffered by the offended person as a result of the misconduct, relative culpability of client and counsel, the impact of their privileged relationship of an inquiry into that area, the risk of chilling the specific type of litigation involved. That's the one that they ignore, by the way. This is the one that they ignore, because if this case isn't frivolous, was just defeated on a technicality, then you risk chilling litigation. This is the biggest problem with the TCPA, is it chills meritorious claims of defamation and other torts. The impact of the sanction on the offender, including offender's ability to pay a monetary sanction. The impact of the sanction of the offended party, including the offended person's need for compensation. Relative magnitude. The offended person, by the way, has stated over and over. Monica Rial has stated over and over that she is a more successful voice actor than Vic. Not only this, I don't think this is ever brought up, but not only did Monica and Ron discuss that in their tweets, I believe it was brought up in their pleadings that Monica has more entries on like IMDb and stuff than Vic does. Monica is a better and more successful voice actor than Vic Mignogna, according to Monica and Ron, which hurts them there. She should be able to pay any of this. Relative magnitude of sanction necessary to achieve the goals of the sanction and burdens on the court system attributable to misconduct, including consumption of judicial time and incurrence of juror fees and other court costs. Defendant has not offered sufficient evidence or any evidence whatsoever to support sanctions based on these factors. It is worth stating that awarding these sanctions requires a finding beyond the simple fact that plaintiff's claims were dismissed pursuant to the TCPA. And that's from the TCPA section 29.009 of the TCPRC. There's no evidence of bad faith, willfulness, vindictiveness, negligence, or frivolousness on plaintiff's part. Plaintiff's alleged valid cause of action against defendants and pled sufficient. Plaintiff alleged valid cause of action against defendants and pled sufficient facts to support those causes of action. That's a shot at Chup. Right there. It is plaintiff's understanding that his claims were dismissed not on the basis that he didn't state viable claims. Rather, the court believed the evidence offered was not sufficient to prevent dismissal under the TCPA. To be clear, plaintiff sued defendants for alleging that plaintiff habitually committed sexual assault, is a pedophile, will be a registered sex offender, and is a predator, all of which are false accusations that plaintiff claims constitute defamation. Putting this in the record is good. Putting this in the record is very, very good. Among other causes of action, Lemoyne, you gave them the opportunity to add that specific claim to the record. Good job, homie. Given that none of defendants' purported hundreds and hundreds of victims ever came forward, it is painfully apparent that plaintiff is the real victim in this dispute. Defendants complain about statements made by third parties. Hi, friends of plaintiff. I'm not a friend of the plaintiff. According to Kick Vic, I've been thrown under all of the buses, and I am now dead. And by the anime community at large, well, that's not me. I don't claim to be a part of the community because that would be disingenuous to the community. Defendants offer no evidence that these other individuals are acting under plaintiff's direction or even encouragement. Plaintiff cannot answer for actions of every member of the anime community that disapprove of defendant's blatant choice to defame the plaintiff on numerous occasions. Not only can he not answer for every member, he can't answer for any member. Not any member. Nor would sanctions deter participation by plaintiff in public conversations centered around himself, especially since plaintiff is not speaking about the defendants publicly. Oh no, we have a... Oh man. We have a Landau apostrophe. An errant Landau apostrophe. Tall Cat, whoa! Big donation, says thanks for your coverage. Help me through a rough time. Please check your inbox for a link to a Dropbox with stuff about a set of cases that might be small town corruption RICO. I will. Tall Cat, thank you. Thank you for that wonderful donation. It means a lot to me. It really does. Plaintiff is not speaking about the defendants publicly and hasn't spoken about them in the public forum. Unlike defendants, since their allegation service. Another errant petition, apostrophe. And another one there. Oh, God. That's embarrassing. Oh, no. Why? Why are the apostrophes? No. No. Defendants have spent most of their time arguing in every pleading they have filed about a third party who has raised funds for the purpose of paying plaintiff's legal costs. I think that qualifies as a GoFundMe, Reed. That's a reference to me in the GoFundMe. Here we go. We have $264,110, and the march goes on. Raymond L, thank you. Anonymous, Brian R, Alyssa, Squally, Flutie. Hey, what's up, Squally? How you doing? I miss you. Matt Fields, Armchair Warlord, Jesse Fritz, and Anonymous, which I think Anonymous and Jesse Fritz might have been on the last one, but I don't care. We're back to it. Thank you guys so much. So much for this. You guys are great. Defendants have spent most of their time arguing in every pleading that they have filed about a third party who has raised funds, I just read that, for the purpose of paying plaintiffs' legal costs. However, as the various defendants, stupid apostrophes, why? What curse afflicted you? Oh, please don't drink and drive. In this case, have regularly highlighted the funds are not payable directly to plaintiff. The existence of third parties cannot be considered regarding plaintiff's ability to pay a monetary sanction. Defendants, apostrophe, have not offered any evidence whatsoever on this factor. Defendants, apostrophe, are trying to distract this court from their unreasonable and outrageous requests for attorney's fees and sanctions by filing pleadings that are harassing and prejudicial to not only plaintiff, but plaintiff's counsel, Ty Beard, which is bordering on, if not, a violation of the Texas Lawyers' Creed. Ooh. They have a creed. And people who are not parties to this lawsuit, specifically publishing the obituary and last will and testament of a beloved member in the Tyler, Texas community. That's for you. That's for you, you idiots. And I hope Judge Chupp factored that in. I hope he did. Your haste to shame me because my grandfather was a good person is just the absolute epitome of scum. And I hope you literally die from it in Minecraft. Absolute garbage. Absolute garbage. Defendants, apostrophe, offer plaintiff's testimony from his deposition to support their allegation that plaintiff must be sanctioned to deter him from filing similar suits. The fact is, if plaintiff so desired, he could sue additional defendants who have harmed his reputation but has not chosen at this time to pursue other lawsuits. Moreover, such a statement does not support an allegation that any subsequent suits against people who harm plaintiff's professional reputation would be subject to dismissal under the TCPA. Any sanction awarded on this basis would improperly deter plaintiff from bringing valid lawsuits in Texas state courts impinging upon his First Amendment rights. In fact, the record before the court on several of these factors weighs against imposing sanctions. For example, defendants, apostrophe, come on! Ryan! Oh! Ryan, consult with me as an English major on your apostrophes, please. I love you, buddy, but they hurt me physically. They physically are wounding me. For example, defendants have shown no evidence of prejudice as a result of plaintiff's conduct. Their own conduct and actions have created the circumstances they claim have been created by plaintiff. Also, plaintiff has no history of filing suits like this in the past. The sanctions awarded should be denied in whole or alternatively reduced. Prayer, wherefore, premises circumcised, plaintiff asks the court to deny defendants' that's the proper one. Request for attorney's fees, to sustain plaintiff's objections, to deny defendant's request for sanctions against plaintiff, and any and all such further relief to which plaintiff may be entitled. Respectfully, Beard, Harris, Bullock, Hughes, and Martinez sue Ryan Sellers. So there you go. That is the final filing we will get through tonight. If you have any further questions or comments, please send them in now, as I am going to start the reading of the Super Chats. And the Justice Chats will be first today. I've been doing Super Chats first for a couple days. We're going to go back to doing the Justice Chats first. There's only a couple to go through. So please go ahead and send in any further questions. Right now is the time. Otherwise, if you do peace out during this part, I respect you and love you for watching anyway. The hate watchers who love to click the dislike button, always click it. Always click that dislike button. It definitely hurts my YouTube metrics if you click the dislike button. It does not in any way help my YouTube distribution for you morons to watch and click that dislike button. So definitely, please, it hurts me so much. YouTube actually sends me an email of every dislike and says, no, you did it bad. You should do videos that people like, not ones that people don't. YouTube specifically doesn't like ad revenue from people who dislike. So if you dislike, YouTube takes my ad revenue. So definitely don't dislike my video. It hurts me very much. It hurts me personally. I just got tea in my eye. That was beautiful. It hurts me. I cry every night. 1 hour. Following Lemoyne's billing structure, I cry for 1 hour per dislike every night. So, and I will put out a tears billing affidavit at some point. Every dislike is 1 hour of tears. One dislike equals 1 hour. So, all right, guys. If you do pass, if you do peace out during the fees or the fees, well, kind of fees. If you do peace out during the super chats, thank you so much for watching. Come hang out tomorrow. We'll have another good show. Who knows what will be on the docket, but I've got some good stuff in the works. Other than that, let's hit these things. I will be on Twitch following today's show. I got to eat something, but Twitch will be happening. All right, we've got justice chats here. We've got Dread Clown. It says, on an off night, can you look for a case where a person hires opposing counsel to sue their prior attorney? I feel like the transcript would be amusingly petty. Justice chat link missing in description. Copy paste better, boomer. That's not my fault. That's actually the fault of my artist, who I will throttle. I will throttle for not including the justice chat in the new description defaults. So, Tillip, you're getting throttled. Mr. Clark. Oh, I read that one. Dang it! I'm not supposed to say that. Bad Dragonite says, a trans female to male who was claiming Vic was a predator tried to call me an incel. Told them they didn't even have a dick to give. The most incel of incels. I fully expect to be yeeted off of Twitter. You're done, buddy. You're done, buddy. Did you guys see that one person... by the way, be cautious, right? Just because someone purports to be I stand with Vic or whatever doesn't mean that they're automatically good. Did you guys see that one person was outed as a pedo? Like a registered pedo, a convicted pedo. I don't know if they're registered. A convicted pedo. Convicted of child rape. Be very, very cautious. Just because someone claims to be on your side does not mean you should automatically support them. That's a weird place to be. Mr. Clark boomered the link, but I provided the link in the chat, so hopefully you guys saw it. Conspiratorial Walnut says, did you hear that the blue whale population has recovered from 4,000 to 2,500? Oh, Renfamous must be slooting out at an impressive rate. Rumor has it this has been caused single-handedly by Monica and Jamie going to the beach and accounting for total mass. Oh, gross. Gross. No, I don't see anything by T. Greg, so I didn't see what he said to Hirohe, unfortunately. Zypher Warrior says, do note that their conviction was them at the age of 12 for an undisclosed act on a 5-year-old. Be cautious, y'all. According to the only pedo I've ever interviewed on this stream, that's not something that you fix. Not something that you fix. You have to be on guard for it your whole life. Be very cautious. It could be gay ops to get you into some sort of trap for supporting someone who's awful. I don't know if they're awful or not. I'm just saying be cautious. Be cautious. People can represent themselves any way they want on the internet. You don't have to blindly support someone. If you support them even after their convictions, go ahead. Go ahead and do so. Maybe you think they're reformed or whatever, and that's fine. You can absolutely do that. But just go into it informed. Mario Carter 13 says, can't afford the entry fee? Become the con slut. Lemon. Christian Delgado says, will you get your Twitter back eventually? No. I will not. I need to actually update my overlay. The intern Chan will be retiring soon. I'll be taking over intern Chan's Twitter account because it's actually the property of Rekieta Law. It is not a personal account, so I will be taking it over. And as part of that, someone from Rekieta Media will be overseeing that Twitter account. So you can subscribe. You can go ahead and follow at Law Archive if you want to follow the announcements for this channel and any discussion that comes from it. That'll be happening before too long here. I'm afraid Intern Chan has been an intern for far too long and needs greener pastures. Also, I kind of want to have some contributions on Twitter again myself. But, you know, that's me. Eventually, and how much has Ty charged Vic so far? I have no idea. That's confidential. Is it more than the GoFundMe has? Is there a document showing it? There is no document showing how much Ty has charged Vic. I have no idea. I don't know. It could literally be any number because I have no idea how many times Vic asks Ty to do something or how many times Vic calls Ty or Ty calls Vic. I don't know how he bills stuff. What I do know and have been assured personally is that Ty does not bill anybody for coming on this show. If you are worried that Ty coming on this show somehow costs Vic money, never. Ty comes on this show out of his personal time. He does not bill for his appearances on this show. And if he did, I would never, ever invite him on the show again. Just so we're clear on that, if Ty Beard were to bill Vic Mignogna for time appearing on this show, I would immediately cease any appearances on this show. So I have been assured that Ty does not bill Vic for any time appearing here. That does not come out of the GoFundMe. That is based on my personal relationship with Ty and his willingness to talk. That's it. No professional time on that. So, there you go. Ichigo Shirasaki 276 says, even Google would rather you get free money than J-Dolph the Lemon Führer. Enjoy the last free super chat while laughing at the wheezing salty lemon. Hey, thanks. Thanks, buddy. Gruber says, when it comes to Lemoyne asking more about what made Chup come to this decision, is Chup just allowed to give them lower fees because he felt like it? It's within his discretion. He'll justify it. He won't just say, I felt like it. Even if that's true, he will justify it specifically with findings of fact. He'll say, no, I felt they overbilled. That's it. Let's see. Billy the Kid Lauren says, please re-inform people how GoFundMe will not pay the defendants. Not $1 of the GoFundMe will go to the defendants. Not $1. Not happening. They can't do it. They can't get the court to force GoFundMe to pay. GoFundMe pays out to Ty Beard, to the IOLTA account of Beard, Harris, Bullock, and Hughes. It pays into that account, and then, you know, the way IOLTAs work is it's client money held in trust by the attorney. So the attorney will bill against an IOLTA account frequently. That's a very common practice. And that money technically belongs to the client, even though it's being held by the attorney in trust. So that money goes to Ty and Beard, Harris, Bullock, and Hughes to be held in trust. If Ty were to misuse that money, for example, say Ty wants an 8K TV, right? Reasonable. Everybody wants one. And he goes out and uses that money to buy an 8K TV for the office. That would be criminal acts. Ask Michael Avenatti who did that. That would be a criminal act. So the money is technically Vic's. It's held in trust by his attorney for the purpose of billing. That's what's represented in the GoFundMe. The attorney will bill against it, and any excess will then go to the Salvation Army Battered Women Shelter in Dallas County, as stated in the GoFundMe. So that's about all I can say. I don't know what the amounts are. I have no idea, but that's there. But yeah, the defendants cannot touch it. They cannot get a judge to order it's turning it over or something like that. That doesn't work. Doesn't work like that. Let's see. Rob Van Pelt says, here's some free YouTube money for the 3950X fund. Nikki, thank you. I did procure a 3950X. It will arrive on Friday, which means I need to go and order and express ship the rest of my PC parts as soon as possible, which I'm going to work on in just a minute. Jared Chi says, hey, Nick, have some free YouTube money. Thank you. Rob Van Pelt says, more 3950X money. I appreciate it. Fluffy Side Up says, Jesus Christ, that thumbnail is terrifying. Rob Van Pelt says, and some more for the 3950X. And he also has one that says, last one for the 3950X fund. Thank you so much. Tiny Kitsune 038 says, last free super chat. Thank you. Rip your free super chats. DJ Fantasy says, did you see the Vic Nerd and Tie web article? I did not. I did not see the Vic Nerd and Tie web article. I hope it's good. Fatal System Error says, Freebie also ordered a shirt. Hey, cool. Thank you. I hope you enjoy the shirt. We got to get a How Embarrassing shirt back up there. I've told my man to do it. Now I will beat him into submission. Pirate Skeleton says, if you think about it, Jamie was the only winner. She's not really a winner, though. She's not really a winner. Vic hasn't paid her fees yet. Vic's ordered to pay her fees. She has to collect them, and that's not easy to do in Texas for an independent contractor. So Jamie's not the only winner. Right now, only attorneys have won anything. And only attorneys have won to the extent that they've actually gotten paid by their clients or someone else. The Dark Knight says, Vic has won the war. They couldn't destroy him. They cannot destroy him. Z-Pinch, and that's you guys. That's on you guys. It's not me. It's not Ty. As much as Ty likes to claim that victory, that's not anybody except you guys who have stood by Vic and the other people who are not watching right now who have stood by Vic. That's who has saved Vic. That's who has cost Monica and Jamie the war. It's you guys. You did it. Z-Pinch says, hey, Nick, in the absence of some obvious reason to find someone's testimony unreliable, is a judge's opinion of one witness being the better historian a point you can challenge or justify on appeal? No. Actually, the appeals court will often defer to the district court judges' ability to hear the testimony directly and discern the veracity of it, the trustworthiness of it. They're better suited to do it because they're hearing it live rather than reading off of a transcript. So they often defer to those sorts of decisions to the trial court judge. Mr. DJ Fly High says, have you seen Rooster Teeth's response tweet to their VP firing? All it said basically was, everyone deserves to feel safe. Call this DV number. No, I haven't seen it. Rooster Teeth is a pile of garbage, and they can eat all of the feces. Chris Shotwell says, before it expires, take my free YouTube money. Thank you. Thank you. Shendo X, thank you for the donation. Deleted says, spank me. There you go. Mad Lad says, free super chat too. Apparently I can only send these to you on phone app. Weird take there, YouTube. D-Man Dog 56 says, so what do you feel is the ETA for appeals next year? We might see some filings before next year, but probably next year. For the hearing is going to be, I'd say, 4 to 6 months out. The Salty Sith says, Kiwi Farms exposed a supposed Vic supporter named Ryuki Joestar as a child predator. Pretty screwed up because the individual had a lot of people on I Stand With Vic fooled. That's who I was talking about earlier. Go look at it and direct it to yourself. Nick Sex says, Nikki, what you meant to say was, thank God Ramos retired. Asterios deserved his fate. Man, I don't know. The Asterios thing makes me the saddest ever because I really genuinely like Asterios and Sriracha, and I want them to have the best. I really do. Brandon Cavallero says, when's the Onizion vid coming? I don't know. My artist wants me to do an Onizion vid. He was just deplatformed off of Patreon. I don't know if I want to pick on him or not. I don't know. I don't know anything about this weirdo. Raider J says, set up a GoFundMe for Moron. I'll put $100 in tonight. No, not without some permission from them to do it. Mad Lad says, super chat number 3. Nick, where does Rial and Markey stand as actual employees of Funimation? If they paid any fees for either, is that a big deal? It's only a big deal because they lied about it. Eric Utt, thank you for the donation. Joni Baloney says, best RHCP album and best/worst RHCP song. What's RHCP? If anyone in the chat knows which RHCP is, I will happily answer that question. I just don't know what RHCP is. Red Hot Chili Peppers. Oh my God. Okay. I don't know their album titles. I don't know. I cannot tell you what their best album was. But I go back to Under the Bridge. It's the first Chili Pepper song I ever heard. I love that song. It impacted me in a profound way because it was the first one I ever heard. It's just a great, great song. I like Californication quite a bit, but Under the Bridge, man, that's the one that's running through my head on a daily basis. I can't believe I didn't catch. That's The Liquor, speaking of. Under the Bridge. The Crowning Entertainment says, I'm late and gay to the stream, but enjoy these free YouTube red dollar dues on me while I catch up. Hey, thank you so much. AD3, A Deadly Assassin. That's how it's pronounced. Says, FF Monica flicks her roast beef. Nightmare fuel for you. I can't vomit hard enough for that. I can't do it. Blaine20 says, I really wish Vic and Ty would go after Lemoyne for trying to drain Vic's bank account. We'll see. We'll see what happens. We'll see what happens. Oh, God. The Dark Knight says, Veronica says, moo while Soye drinks that soy milk. Oh! Oh! Oh, the Ralph Panino. Why are you guys horrible tonight? Here you go, my friend. Always love your content. Enjoy my free super chat, boss. Hey, thanks, buddy. Duden2217 says, I'm starting from about an hour in the past, but I can still feel the almighty call of the grift demanding this YouTube money. Take it, you fiend. Gladly. Chris Shotwell says, another YouTube paid chat. I really enjoy the show, even if it does keep me up late most nights. I do apologize for that. It keeps me up late too. Mad Lad says, final free super chat. Thanks again for everything, Nick. You give me hope this world won't fall to this trash. Happy Thanksgiving to you and yours. By the way, I am strongly considering cooking a turkey tomorrow, even though I'm cooking a turkey on Thursday. But I'm cooking a turkey tomorrow for my Patreon and New Project 2 subscribers. Hang out. Watch me cook a turkey. It's like 4 hours. 4 hours of exclusive content. I don't know what I'm going to do. I don't know what I'm going to do. Maybe I'll be naked. I don't even know. But I'm strongly considering cooking a turkey tomorrow so people know how to cook a turkey on Thursday. Because I cook a mean turkey. Let me just tell you about that. So if you are not Patreon or New Project 2 subscribers, go ahead and hit that subscribe button at the $5 or higher level and join me for an exclusive turkey cooking with rackets live stream that may be happening tomorrow. Thursday, I don't know if I can stream on Thanksgiving, but I might. Because I'll be cooking a turkey for tomorrow's turkey is 13 pounds. Thursday's turkey is 21 pounds. It's a big flippin' bird, okay? But I'm going to cook tomorrow's turkey, and then I'm going to make a broth from it to make the turkey gravy on Thursday. Smirt. Duden2217 says, here's another $5 that Führer's lemon grabs con sluts won't get to see. Robert H says Lemoyne got pink socked by Chuck. Oh God. M. Franklinstein says free chat. Thanks for covering the case. My pleasure. Sprite Cola says, can you say, yes, they're fresh. They're not frozen. Eagle Lone, I do not buy a frozen bird. Sprite Cola says, can you say Lemoine for me? Saying it like people say, wow, Luigi brings me so much happiness. Cheers to any good news on the court case. One more time. Lemoine. Life of Sarcasm says, oh, by the way, I am told Martinez called him Lemoine. No, Lemoyne at the hearing, and that he corrected Martinez to say Lemoyne. So Martinez is like, opposing counsel Lemoyne, he is overbilled and such. He should not be granted fees, you know. And Lemoyne's like, Lemoyne, it's Lemoyne. Just see that. And Martinez, please forgive me. I apologize that you are Slow-Mo Rodriguez. You just are to me. Until I meet you and can properly actually imitate you. Life of Sarcasm says, it's impossible claims usually end with someone saying, hold my beer. Cemetery Lady says, how do you know so much about ICP? Whoop, whoop. Listen, as I walk down a southern trail, I'm going chicken hunting. Super Sunny says, and I would have gotten away with it too if it weren't for you and your nosy conslutes, the asthmatic lawyer gasped. The Dark Knight says, here to insomnia, long live the night owls. Hot Fuzz says, Nick, delete system 32 to avoid boomer error. Just a second, I'll start that. Travis Whalen says, concrete finisher here, 14-hour shift work, 2 weeks at work, 1 week at home. 1 hour break, 2 15-minute breaks throughout. Like I said, there's some real men out there who do real work. Don't pretend that we attorneys match you. Architect of Fate says, I resent the implication that I do not work more than 7.8 hours a day. Average 12 to 16 with at least 8 hours of solid work per day. I don't buy it. I don't buy it. Maybe you do, but you got to tell me what you do for me to buy it. And if it's a real job, maybe. Tara Sophia says, what if they said, guys, white collar employees are not working 8 hours a day. If you're a blue collar employee, I might buy it. I might buy it. If you're a white collar worker, no, half of your day is spent masturbating in the bathroom while no one's looking. The other half is spent pooping and on Facebook. Tara Sophia says, what if they said, make bill size of the GoFundMe? They did. They literally said that. Andrew Young says, CNC machinist here, making airplanes for Boeing. 9/11 official story is horse dung. And I work 7.8 hours every single day in a 12-hour shift. Absolutely. Lord Blackwind says, just letting everyone know that Jack Daniels is a great whiskey and anyone who says otherwise is wrong. Can't change my mind. F! No, you grifted me. Bad Vibe says, beep, beep, here comes karma. Where are we? Oh, where'd we go? Squally says, aw, don't the lemon tears just flow? Hashtag F yourself, Sean. Oh, man. Name says, you know what? I love a Swiss. Melted Swiss cheese on a burger with roasted mushroom caramelized onions. It's really hot stuff. And you can get that at a number of different places. Prometheus Zeta says, huh? So I take it this means Soye won't get back that snack tray money. He's not awarded it, and recovering it's going to be really tough. Brad Russell says a wild super chat appears. Siren Jack says, hey, rackets, do these apostrophes bother you? Yes, all apostrophes. Even proper ones bother me. Asmodeus says, oh, wait, I haven't read that one. D-Fry says, hey, Nick, any news on the cocktail stream? I'm always looking for new recipes for my own videos. I got to contact my man and get that cocktail stream. No, not a cock stream. Damn you, liquor. I quit drinking now, immediately. Cocktail stream. I got to organize it, hopefully in time for Christmas, because that guy's just great. Much love. Nathan Ashcraft says, is this filing good for Vic? And I hope to meet you. This filing is good for Vic. I'm now slurring. This is not good. Hope to meet me. Either come to Minnesota, I'll gladly meet with you. Otherwise, you know, if I'm ever at a con, meeting the consulates, I'll let you know. Nova Zero says, don't worry, Cox stream in 12. Nova Zero says, what happens if the money goes to the specific shelter for battered women and they give some of it to Monica due to Ron-related remote and or battery? Then she would earn it. Character Holding says, backwards swastikas for all white men are evil. Vic is stealing from the public. Antifa is anti-fascist. Another lie you can think of. Okay. Zypher Warrior says, so the Boomer build video is coming soon. Oh my goodness. Yes, I will be. By the way, when I get all my PC parts, I will be streaming the build on Twitch, and you guys can all make fun of me for thermal pasting all over everything. Like the thermal paste will squirt out too far. You know what I'm talking about. And like getting the PC's eyes and stuff, and that'll be bad. Nathan Ashcraft says, do you like Johnny Walker Blue? I can get you some. I'm having a conflict of interest because I always want a nice whiskey in my house. The last time I had Johnny Walker Blue, I did not think it was worth $230 a bottle. I am willing to have my mind changed by a fresh bottle, but I would never ask anyone to actually send me a bottle of Johnny Walker Blue. Does that make sense? So if you send me a bottle of Johnny Walker Blue, know that my personal experience is that I think Johnny Walker Blue is overpriced. If you send me one to change my mind, I'm not going to argue with you at all, and I will enjoy it even if I think it's overpriced. But I will give you an honest review. How's that? Cesario JBN says, but please do not feel, I do not want to indicate in any way that I hope you send me a bottle of Johnny Walker Blue. That's entirely your decision. I will graciously accept any whiskey you send me, even Fireball. Cesario JBN says, here's my free money from Google surveys to you. Thank you so much. Deep Fried Lettuce says, Boomer Lawyer versus The Verge. Who will be worse at building a PC? The Verge. I've built one before. I'm running on one right now. Big Red the Bard says, take my survey money before it expires as well. Thank you so much. Devil of the Shield says, here's some free money. Question for you though. Do you like mead? Yes, I love mead. Good drink in my opinion. My opinion too. I like mead. I like flavored mead and regular mead as well. It's like beer without the hops. It's perfect. I have a bottle of mead. I have a bottle of $1 million mead. I've been waiting to crack this. Waiting. Look at that. Look at that beautiful art. You got Dick Masterson with a couple ladies on there. This is the $1 million mead. The $20 million mead. It is 17% alcohol by volume, and I will happily drink it. There are only 20 bottles of the $20 million mead made. This is number 13. I was told to let it sit for at least 6 months. It has been sitting for a year. God, it's going to be good. It's going to be good. Okay, next. Mike Testa says, whatever happened to John Michael Kay, the guy who cried boy about you while eating Burger King? John Michael Kelly has been really quiet. I heard a rumor that I cannot confirm that he was investigated by the FBI or maybe Homeland Security for threatening to murder Zoe Quinn back in 2015. I don't know if that's true. That's just the rumor I've heard and why maybe he's been so quiet. But he seems to have realized that he will never get on my show and is absolutely ineffectual. Big Red the Bard says, long-awaited sequel, Survey Money Part 2, Electric Boogaloo. And then no, not a final one. Big Red the Bard, thank you for the donation. It says, no one likes expired money, to be honest. That's the final one. Thank you so much. Devil of the Shield says, here's my last free super chat. Rip your free super chats. But do you think Vic can make a huge comeback to voice acting? Like do more than he is right now? It depends on what you're talking about. Is he coming back to Funimation and Rooster Teeth? Probably not. Can he voice other places? Yes. Can he do independent voice acting and change the way that voice acting is done? I think so, and I hope so. And I would love to be involved in it. We'll see. If I can somehow help him do that, that would be a great, great pleasure in my life. Rick Nikita says, I missed the whole stream. Could you recap everything you said already in detail, please? Think of the children. Are you calling yourself a child, my friend? Let me recap the stream. The only good hot dog has ketchup on it. Or the only good dog, if you're Obama and you're eating dogs. Mike Testa says, bread tube is garbage. Why does it exist? I don't know. Bad Dragonite says, roast beef and jelly bean sandwich. Character Holding says, happy Thanksgiving, you too. Cowboy FMJ91 says, take some YouTube dollars on me before they expire. Squally says, sorry for being so quiet. I work at 5 a.m. CST now, so it makes attending difficult. I'll follow up with you, though. Happy Thanksgiving, Sunshine, Squally. Happy Thanksgiving to you, Squally. Character Holding says, pardon the turkey. No. No turkeys deserve a pardon. They all deserve to be murdered for being absolutely stupid animals. Mike Testa says, NBA lied about taking a break from YouTube. Pity. It is a pity, isn't it? The Umbro 2011 says, oh no, now I'm late. Take my free super chat. Thank you. Rusian Bot says, get yourself rhino milk for the soul. Ty Beard says, Mike Martinez's voice is more like Ricardo Montalban. I can't pronounce that. Hey, what's up, Ty? Welcome to the stream. 7 minutes ago. Go to sleep, you boomer. Sakagi Onsai says, considering this week is a holiday week, what does the schedule look like? Personal prediction on appeals, 7 to 12 of 17 actions reversed. J. Sean, no money. Hashtag J. Sean, no money. I don't know that the holiday week is going to hamper appeals, although I may have babysitters for my children on Thanksgiving night, which might mean that, not appeals, which might mean that streaming is not going to happen on Thanksgiving night. But I know a lot of you people are real Americans who both work on Thanksgiving night and might be done with your family activities by Thanksgiving night. And as true Americans, do not participate in degenerate Black Friday sales. So I feel like I might want to stream on Thursday just to provide you guys with something to watch. I don't know what it'll be, though. I will announce as I figure it out. Sakagi Onsai says, considering... Oh, wait, I read that. Dang it! Architect of Fate says there once was a lass from Leeds who circumcised men with her teeth. It wasn't the skin she was interested in, but the layer of cheese underneath. Oh, God! It sounds like Ginsburg. Mario Carter 13 says, stream thermal paste from your cock, daddy. Ravelin 1 says, I give thanks for the law explaining and the GoFundMe that is allowing us to support Vic's quest for great justice. Happy Thanksgiving to you and yours. Back to you. Disabled Llama says, not sure if it is in the same in the US, but AMD processor fans come with thermal paste already applied here in Australia. Recently built my PC a few weeks ago. It is not the same for the 3750. The 3750 or 3950. The 3950X does not come with a processor cooler of any kind, and you have to produce a third-party solution. Typically, an all-in-one cooler is recommended. So, or an all-in-one cooler or a custom water loop is recommended. So there will be no thermal paste on the processor. Let me run this outro. Here we go. Here's the outro. Better turn it down just a hair. Okay. Asmodea says, best hot dog is Chicago style. Change my mind. Put ketchup on that thing and I will change your world. Car just says, Nick, if you're not going to OC your build, you should replace thermal lassen with a carbonate pad. I don't even know what that means. Noctua rules. Overclock. Oh, not going to overclock your build. You should replace thermal lassen with a carbonate pad. Noctua coolers. I have been looking at the Noctua air cooler. I heard it's really good. In fact, outperforming some all-in-one liquid cooling components. I just got to do a little research and buy the right one. Mike Testa says, didn't John want Vic to die rather than fight it? Yes, all of them wanted Vic to die rather than fight it. Kuro Tengetsu 91 says, anti-fascist is a garbage terrorist group. These soys need to go back to Twitter. Ravelin 1 says, YouTube wants you paid. Who am I to disagree? Never disagree with YouTube wanting me paid. Mike Downme says, Mr. W's GoFundMe is at 9230 out of 10K, just saying, hey, Ty, are you still watching? Ty, are you still watching? If you're still watching, I'm going to put up a challenge for you, Ty. Whoops. Mr. Ty Beard, as a teacher, if you are still watching, I challenge you to donate to Mr. W's classroom library here. Is he still here? He is still here. I see you. Don't even pretend. I challenge you. It is at $9,230. As you can see, I will match any donation by Mr. Beard up to, I gotta put a cap on this, up to $500. I will match any donation by Mr. Beard up to $500. Ty, between you and me, we can send Mr. Heath Wetzler over his $10,000 goal. I will match any donation up to $500 from you, Ty, if you're still out there. Don't you dare pretend you're still not here. You let me know when you donate, and I will match it. You and me both. I've given you up to $500 to match. We've got to cover 770 total. So we can cover it. We can cover it. Fluffy Side Up says, "Did you read my Justice Chat?" Not yet. It's I believe it's right here. We'll get to it in just a second. TLJ Screwjob says, "So does the quote plaintiff can sue others if he chooses section, as in that whole paragraph, mean that Vic can send A&N a 'we may sue you' thing before the statute is up, or would it be bad for Vic?" No, he can do whatever he wants. The court has ruled. Court has ruled. Fluffy Side Up says, "You should do a legal writing workshop for fun on here. Make polls on the community tab for facts of the hypothetical case and have Ty or someone be the opposing party. I think it'd be a pretty neat and fun thing to do." That could be fun. Ty's probably really busy for that. Anonymous says, "Don't ever rap again, Nicker." Rude. Rude, my rap was brilliant, and you know it. Austin Heartless says, "Gonna email you about CPU coolers from my experience." Thank you. Thank you. Mike Testa. Mike Testa says, "Lemoyne is the whistleblower. Get him. Happy Thanksgiving, Nick. Blessed be the dawn. Go on EFAP, please. Legal Eagle it. Legibny? Who is... I've heard of EFAP, but I don't know what it is specifically. Prometheus Zeta says, "Take my last free super chat. Thank you. You should cover the digital homicide lawsuit one night. Seriously, that lawsuit is almost as insane as the Greer suit." And E1337 Neo says, "Hey Nick, have another pair of sawbucks for me for helping me cope with the midnight oil that lasted a little longer than expected. I work as a web developer, so your guess on how many hours I actually worked is as good as mine. 5. No, I'm just kidding. Web developers are almost blue collar. Almost blue collar. Every frame of pause. Yes. I would love to go on their show. Love to go on their show. Mike Testa says, "Drake, where's John Michael's channel?" All right, Ty. I know you're out there, and I know you hear me. That challenge to you is up. I don't care if it happens on this stream or not. I will match you up to $500. And between you and me, we can raise Mr. Heath Wetzler over the $10,000 goal to put books in the hands of kids. So there you go. All right, guys. I gotta sign off. I gotta get to Twitch. I gotta get to the bathroom. I gotta get to the kitchen, and I gotta get to Twitch. I will see you all in a bit. Peace. Peace.